True feed they go shine like tower. We no go fear, we go talk. Even if they know I make we talk. True big radio on FM 103.9.
Now God we dey pray, they not true we dey preach. Freedom of speech, now that we dey teach.
For salon, we go stand tall. Radio, true PJ.
One voice for all.
We honor the land, the struggle, the fight. We shine a light in the darkest night. Because we believe in hard work and faith. The Sierra Leone way. We hold the line, come what may.
Them one set we more them, but we go shout. Now the poor man voice we they bring out.
Now we alright for know the truth. Now that make we go protect the truth.
True big and not they neglect anyone.
We are the voice we.
This is Truth Radio, 103.9 FM. We empower the nation.
5 minutes to settle down.
Thank you, sir. Thank you, sir. In the process, Mr. Chairman, you can think of some of the things that I'm going to say now.
Yes, please.
Yes. On page 21, you can see the third paragraph. I raised that point during the debate. It was talking about issue to the successful candidate a certificate of election in Form D set out in the 5th schedule. Now we have to be specific here. When you look at the Constitution, has no 5th schedule. Then the 5th schedule in the Public Elections Act have no Form D. So we have to really place that particular aspect. It's a drafting issue, but then again, it's very important if we're talking about forms that are going to be issued out. It's very important that we take that into consideration. Then, of course, we're not there yet, but again, you think about that. Page 22, section 21. From the debate, there was that kind of agreement that we're talking about the Political Parties Act, about the registry of political parties, which of course from this end we argue that there is something not within what we are looking at. So again, that can be taken out of this consequential provision.
I know you've done your assignment and you're in order to make presentations. But we're on page 18. You have been reading throughout this weekend. Yes,
So on page 18.
Page 18.
I know we've struck a pin on the qualifications for the Chief Electoral Commissioner. However, I want to read page 18 in tandem with the requirements in page 3 of the same bill. So the requirements that are placed in page 18 for the qualification of the Chief Electoral Commissioner ought to be the same as the qualifications in page 3.
Of course.
So when you look at the two, they're different. So I think it's a matter of harmonizing the requirements and agreeing on them.
Yes. And the legal government business.
Mr. Chairman, I don't know why the ED is wasting time to deal with the consequential amendment. For now, we have said that we really don't need the consequential amendment. We don't need it now. I think it should do us a favor by just removing this whole part from the bill.
Yes, Mr. Speaker, honorable members, good morning. As indicated by the leader of government business, there is my submission that the provisions or the proposals relating to consequential amendments starting from page 18 be put on hold because this is actually in line with section 173 of the Constitution of Sierra Leone, which reads with your name, Mr. Speaker, that the provisions of any consequential provisions act made under this Constitution or any act relating to citizenship shall not be amended, repealed, reenacted, or replaced unless the bill incorporating such amendments, repeal, reenactment, or replacement is supported at the final vote thereupon by the votes of not less than 2/3 of members of Parliament. So it's a submission that the focus remains on the bill itself right now, and once we get a vote on that bill, and then this House can do consequential provisions. That is what section 170 in addition, yes, it is my submission that the consequential provisions.
Can you move? Yeah.
And it is also a submission, honorable members, that while we need to remove the consequential provisions for now, in fact, the provision relating to clause 21, that one will be deleted completely because it will not be part of the submission.
From 18 to 21.
So from 18 to 20.
From clause 19.
From clause 19
to 21.
Yes, Mr. Speaker.
Yes. So, Leader, can you please?
Maybe I'm wrong here. Why do we need to move the constitution and provision which we cannot back from?
It's all right. He's the one who is piloting the bill. So if you say that he does not want that again, we cannot
That is correct, but his authority is not above that of the constitution. The constitution is very, very clear.
It's all right. Honorable, it's all right. Let's do that. Please move.
Chairman, the commitment for the DPRC Act, and also when I asked for the Saturday, section 25, section 27 of the Constitution, based on such provision 9,219, the minister made commitments. And also, you are just quoted for question amendment, the library constitutional provision. And 21, the provision. So part 2, that has to do with question amendment, be deleted from the bill. So,
Any seconder? Any seconder?
I also second Mr. Speaker.
All those in favor say aye. Those against say nay. The ayes have it. Part 2, deleted. Honorable members, we go back to those areas where we stop pigs and deal with those clauses one after the other. Beginning with clause 1. Clause 1. One reads to be specific. To be specific, I think it's 1B. 1B, yes, 1 signature. Yes. Yes. So what do you see? What do you say, Honorable Mary?
Again, Mr. Chairman, it's the issue of such committee that you had there. But it's clear, 171.14 is clear about not being bound or whosoever. We have your attention, Mr. Chairman. The search committee is going to sit and make a decision. They will bring forward nominees to the president. But in this constitution, whatever the process, the consultation process that might have taken place, subsection 14 of 171 makes it clear that it's not bound by the outcome of that particular consultation or that advice. 53.3 is also clear on that. So why do we need to bring a group of people together, not for free at some point, spend all the time deliberating, make a decision, but at the end of the day, whosoever they are going to present this decision to is not bound by the outcome of that consultation.
What do you say?
So, again, it's something like the operation was successful, but the patient died. The man who bring in this decision already has the power to even make that decision. So it is against this backdrop that we are saying, let the consultation process be clearly defined. In as much as, again, he's not bound by the outcome, so why take the powers from him when he can even reject?
Waste of time.
This is the question we're facing. We bring them together, they make a decision, but when they bring it to the president, he still has the power to even reject it. So why not make them, again, we're looking for some other opportunity to bring people together. We spend resources, just like we're trying to ignore all the other resources for the time and effort spent on the previous consultations, the white paper. So let's not make it a habit of bringing people together. They make a decision, then at the end of the day, we walk away from whatever recommendation. So what we have now is, we have even all the political parties who are not even part of the search committee. So what we are trying to do, to even politicize this other groups that will be speaking through to power. The sooner they have the opportunity to determine who conducts the election, they automatically politicize. That's why we're going to start World War III. Who becomes a member of that particular committee? Because at the end of the day, they are going to determine the results. So again, we can prevent all of this, Mr. Chairman. He has the power. Let's make a decision in consultation with all the parties. I rest my case, Mr. Chairman.
Yes, Honorable Leone.
Mr. Chairman, a successful operation, the patient dies. Two things be satisfied. The patient is satisfied that he was not abandoned when he was sick. Secondly, the family feel they've done their best. What we seek to address is a democratic credentials that befits our nation. We know the outcome rests on the president, but at least it befits a situation in which the citizens will know there was a process that is credible. Is that too much to ask for? Politicizing the CSO, it should not be your worry. Besides, we have people who serve in the executive that were CSOs. We are not politicians before they came in. Because somebody is telling us he has owned membership 15 years before he became PRO. Let's go to the core of the matter, Mr. Speaker. What we cease to do as a nation is correcting the very mistakes we've had, the very complaints we've had, election in, election out. Restoring the confidence of the people that their votes will count and their votes matters. Restoring democracy to the country that the people have confidence that when I get up in the morning 5 o'clock and I go to that queue, I am voting in the person that becomes the president. And the person who becomes the president has the confidence that I am leading the people that gave me their mandate. It's a social contract theory in which we give them our authority, they give us the social services. Therefore, we are not asking for too much. We are not saying the search committee nominates the president automatically. No. They are only part of the process to ensure we have a credible person in the office. Is that too much to ask for? But the trouble is, we already have a situation of consultation. Are we admitting that we very well knew it was done wrongly? And we were finding a definition for it all this while. We have a president that is so considerate, but yet still he could not do consultation for 8 full years in a manner accepted by the people of CNU. Are we living that again to the same situation of having it to define what consultation means for us? If we were supposed to beg, we beg for this. For the credibility of our process, for the credibility of our mission, for the acceptance of our result. Let us just allow the situation we are in. But I find it difficult to ask what are we arguing over. As a chairman of the committee, the select committee, after doing everything, I report to the speaker, who is the arbiter and who is the head of this house. So I now come at the committee stage where I chair, where I should pretend as the speaker. It's not finality until the speaker says so. So why is the speaker worried? Mr. Speaker, in terms of resources, if we want to save resources, let me say this. Even the people out there will not see us as one people to be paid. We can save resources by leaving this house, and then people have more resources. So I am saying my position is clear and our position on this side is clear. Let us save democracy. Let us assure the people of having an electoral commissioner that befits the status of our democratic election.
Yes, I don't think we are here. Of course, I want to and our position on this other side was very clear, the true sense of patriotism. Make law not because they are sitting on the side or the interest on a normal temperature and pressure on all sides to have the final say for the good of this country. We have made our position. We are going to that law, the extant law, is going to remain the same. And we ask that there is any definition of consultation, we take it to the Public Elections Act, where will be the general administration of the law. They didn't give their proposal. You cannot do the administration of the law in the constitution. You can take it to the Public Elections Act. Define the law. I don't want to go back and go over and over what I've said. I have said the 10,000 number. While the president did for the appointment of the electoral commissioners, I asked my colleague 10,000 number that go to the Supreme Court for interpretation. For us, we start with the extra law. We are starting with the extra commission. I respect this. No more submission on this side concerning my no more submission. Yes, the leader of the opposition.
Yes, Mr. Speaker. I similarly believe that we've had ample debate on this topic. And no form of debate will shift anybody's position. We proffer in business for which we are against that very clause in the Constitution. And with all of the debates, if we still stand our ground, then I believe even if we open another debate, we'll be here for the rest of the day. So I want to crave from your indulgence, sir. You are the head of this house. I want to crave on your indulgence, sir, and we proceed in the process. Because it's clear, one of the reasons one of our members stated that even when you define consultation and you have a sitting president who does not go by it, who will reprimand the president for not honoring the Constitution, it will be a job in futility. So we still stand our ground that we're against. We want that very clause in the amendment, and that position is our position.
So, the leader of government movements, can you state your position and move your motion? Mr. Chairman, I have stated I have the Kataka provision with me. Our provision, though we are in the opposition, presented the SAC committee as it is, rejected by the then government in 2017. Both the Peter Tucker and the Justice Kawa, in blessed memory, both of them, that said, let us sustain the extant provision that has Rule 32(2) of the Constitution. Whatever definition we have to do, we will address that one in the Public Elections Act. I so move that we stay with extant law.
Your position is that we stay
the extra bill.
Yes.
Any second?
No second, Mr. Speaker.
All those in favor say aye. Those against say nay. The ayes have it.
Mr. Speaker,
Yes.
we are looking at an important document which is the Constitution. Firstly, I want to rise on the SO 46
Order. All of you in the gallery. All of you in the gallery. Don't take part. You are citizens of the Republic of Sierra Leone. So you are right to be here. But you are not right to take part in what is happening here. Otherwise, I will withdraw your right and send you out. So please keep quiet and listen to what is happening here. At the end of everything, you can go to your members in their offices, you can go to their homes and tell them, SO2, oh, I like the way you talk today. But not here. Please, proceed, Honorable.
Mr. Speaker.
Sorry, leader, please.
Yes, Honorable.
Yeah, Mr. Speaker, as time is too long. So I move I also have to suspend for the business of the House to go.
Yes, any seconder? Any seconder?
I so second.
All those in favor say aye. Those against say nay. The ayes have it. Yes, leader of the opposition.
Yes, sir. I rise from SO 46-1 to challenge your ruling, sir, and let it be on the records the number of people who voted in favor. And Mr. Speaker, this is about altering the Constitution, and I'll come to that. But firstly, I stand on SO 46-1 to challenge your ruling.
Thank you very much, Honorable Leader of the Opposition. So I'm going to put the question again, and I will rule. Yes, Leader. I'm putting the question again. Hold on.
Yeah, Mr. Speaker, before you put the question, my challenge is as a result of the fact that I am not convinced with the collection of voices.
Yes, that's why I'm putting the question again the second time. All those in favor say aye. Those against say nay. Yes, proceed.
Honorable members, of course, you will not need to have a very loud voice to vote in Parliament. Because if it were that, they would have got to look for those with the loudest voice to be elected in Parliament. Parliament is the house of procedure. We have seen and noticed that during the process, we have seen and noticed that during the process, there is immense participation from the gallery. And Mr. Speaker, That is why I want us to have a head count so that we can have a specific number of members of parliament who voted for and those who voted against. That is why I am standing again on SU 46 to challenge voice leadership.
Members, a division has been played by the leader of the opposition. In the circumstances, I call both leaders to call their members who are outside to come in. I'm giving you 10 minutes to make sure all your members are here. 10 minutes, Sergeant Atam. Sergeant Atam. Clear the chambers. All strangers. Leave the chambers.
No idea to all the constitutional amendment. The 50% or 50 plus 1 is that the 50 plus 1 we at the last election with the PR system, me personally I support. The reason be that we all know that this country that they do election, we don't see they get amendments. So we don't get runoff or we cancel may not die or may not die. How can I call it? Honorable don't die. We don't do that runoff election. A lot of problem, other halala they do, other things they do. So you see, so me, I dey talk to all the countries for me to accept that PR system because now the political party then they dey appoint policy 1, 2, 3 policy after this policy na this policy after this policy for example I dey know give example to the council wey dey don tell me time may so let's speak councillor Oji wey he die no election they just appoint one wey dey second but they dey say now say we can do election that hala that first that other thing all two so see so me Professor Binya I support the PR system and the 50 plus 1% I support that very well.
According to the citizens of this country here, we dey try our best for let government system try for improving this country here. The 50% wey dey 50.1% wey dey count and so now they fine for let you become a president because traditional 55% wey dey defend pass no more go per runoff. So now we say we no go one runoff, we want 10 go because that runoff then a waste of resources na this country here. So we money dey go. Besides that, this PR system wey dey count na the country, me I look at and say I no get problem with that day because every constituency wey you say na this policy allow make as a constituency let policy to map na here the people that dey work go meter too much. But now the PR system, it depend on now. It easy for everybody. It depend on wetin you can do for the people there. If you get power, you never then it's okay. Because government business, government ain't get everything.
Maybe this PR system I no say na better thing for we Sierra Leoneans because we be very slow that wey dey go vote that we go honorable go councillor there.
notify your members.
Internet okay?
Madam President of the Press Gallery, please identify all those that are seated that are not your members of the gallery. Just identify them. And I ask the security members to take them out of the chamber. If you know you are not part of that press gallery, leave the chamber. Mr. Get up and leave.
All parliamentary staff leave the chamber with the exception of the sergeant at arms and the table clerks. With the exception of the sergeant at arms and the table clerks, all staff leave.
If you know you are not part of the press gallery, leave. This is
Honorable members, please resume your seats. Honorable members, kindly resume your seats. And if you are not a chamber staff and part of the sergeant at arms, kindly also leave the chambers if you are a staff. Can we get the registered members of the press gallery to kindly sit down? Honorable members, please resume your seats. Honorable members, I wanted the party leaders to stay, but unfortunately, this is a very strict parliamentary procedure. Normally, in votes of this nature, we don't allow strangers to be around. But I will allow the leaders, all political leaders, to occupy the diplomatic gallery. Please, leave this area. I'll allow you to occupy the diplomatic gallery. Please, all parties take over. Go to the diplomatic gallery. Sergeant Atal, please guide the stakeholders to the diplomatic gallery. Mr. Chairman, can you specify who will cooperate alliance? The chairman of the political parties and their secretaries.
Thank you.
Chairman of political parties and their secretaries, and former chairman, former secretaries.
Mr.
Yes.
Mr. Dwight.
This is not a secret society. This is not a secret.
Honorable leader, this is my chamber. This is my chamber. I don't think this should be argued like that. This is my chamber. And even for I think we have another vote. I think for the auditor, yes, we also sent everybody out. No. Okay, this time we don't want strangers within the way. They can go. That's why I told them to go. Please leave out the opposition.
Mr. Speaker, we can't do this.
Okay,
Go up here. Double foul.
Select five. Where the diplomats stand? Leader of the opposition, do you know why this is done? It is done for the security of members. And we have seen in cases where people are shot, members of parliament are shot for exercising their vote. Do you know that? In fact, at one point in time, recently, while we were on this debate, probably I didn't inform you, somebody was caught with a missile coming to the gallery. Somebody was caught with a missile coming to the gallery. It is for the security of members. This is not a secret society. It is just the security of the members.
Yes, Mr. Speaker, I agree with your ruling. You are worst of it, you will not be sure that
Mr. Chairman, I think it should not be. I still have issues. I don't see us challenging your ruling. I don't see us challenging your ruling. But I was thinking that, can I have your attention, sir? I was thinking that.
Hold on, leader. Member, please now. Occupy your seats. All members. Occupy your seats.
Mr. Chairman.
Yes.
As I see, we still have chaos in the chamber all over the place. So I'm asking for the full enforcement of SO 79.
Yes.
I'm asking for you to invoke SO 79 for equity and fairness. SO 79. You draw up all strangers.
We want 5 from the APC, 5 from the SLP, and 1 each from all the political parties. 1 each from all the other political parties. If you do not belong to this category, please leave. Yes. It's not about decorum again. In this case, it's about my ruling. I said 5 from either side, then 1 each from all the political parties. Of course, the diplomats can stay, and the journalists can stay. Former members of parliament can go up the gallery. Former members of parliament. Yes. So, Sergeant at Arms, defend that.
Mr. Chairman.
Yes.
Are we sure that all the journalists are accredited?
No, leave them, the chief whip, leave them. Yeah, let me hear the clerk.
Yes, and Chief Whip, you recall, Honorable Chief Whip, you recall that I drew the attention of the President to the effect that she has to identify those that are accredited to Parliament. For those that are accredited to Parliament, the list is with me.
Sergeant Atam, tell your officers to occupy the entrances. Nobody comes in. Honorable members, like I informed you, a division has been claimed by the leader of the opposition.
Let them go to the gallery.
In the next 2 minutes, we'll be taking the votes. In the next 2 minutes. Sergeant at Arms, occupy the doors. Sergeant at Arms, I'm seeing somebody using that entrance.
Who's that? Bro! No, let it go to the gallery.
No, please clear the chambers, please. Yes, please clear the chambers. Go to the gallery.
Dale.
Wow. Yes, yes. Vamos.
In the next 1 minute, we shall be taking the votes. Sergeant Atan, close all the doors. We'll be taking the votes on the clauses. Just on the clauses. And we'll open the doors briefly for members, for you to relax yourselves. Then we'll come to take the final vote on the bill. But now we are dealing with the clauses. There is a motion on floor by the leader of government business, and that motion has been seconded. And the leader of the opposition has claimed division and has challenged the decision of Mr. Speaker. So we are going to the votes. I'm going to ask all those in favor to rise in their seats to be counted. After you have been counted, you also call all those against to rise in their seats and be counted. Honorable members, all those in favor of the motion of the leader of government business to the effect that the provision in the extant law remains and that the definition of consultation be done in another act. All those in favor say aye. Aye. Can you please stand in your place? Those in favor, can you please stand in your place and be counted? Mr. Clark.
I listen to the leader. Oh, okay. Yes, I will now.
Sit down, please sit down. All those against the motion say nay. Please stand up in your seats. Please rise in your seats and be counted. Leone? Yes, sir. Okay, please sit down. Yes, Mr. Clark, can you report?
With the leave of Mr. Speaker, honorable members, the ayes 96, the nays 49.
In the circumstances, honorable members, the ayes have it. So the extant law remains.
Mr. Speaker.
Yes, I read out the opposition.
This is a very critical voting. This determines an amendment to the Constitution. And Mr. Speaker,
Honorable, please keep your undertones. Because we want the public to hear what we are doing here.
Because, Mr. Speaker, the committee stage is very critical. In fact, it is the stage that encompasses the real process of changing the Constitution or amending the Constitution. This is the stage where we delete clauses. This is the stage where we insert new clauses. This is the stage where we change the constitutional wording. This is the stage where we substitute previous provisions. This is the stage where we vote on the passing of those very clauses. And Mr. Speaker, Section 108 is very instructive. It says that for the amendment of the Constitution, so Section 108, which is an entrenched clause, specifically deals with the amendment of the Constitution. And Mr. Speaker, when you want to change is, you want to change acts, you want to change a comma in the Constitution, it should be followed by 2/3 vote of members of Parliament. Mr. Speaker, let me go to 1089. Let me go to Section 1089, Mr. Speaker. It's very clear. It says, Section 1089. It says, this section, in this section, a references to the Constitution include references to any law that amends or replaces any of the provisions of this Constitution, and B, references to the alteration of this Constitution or any chapter or section of this Constitution include references to amendment, modification, or reenactment with or without amendment or modification of any provision for the time being contained in this Constitution or chapter or section thereof, the suspension or repeal of any such provision, and making a difference, the making of different provisions in lieu of such provision, and the addition of new provisions to the Constitution or chapter or section thereof, and references to the alteration of any particular provision of this Constitution shall be construed likewise. So, Mr. Speaker, it is very clear that Section 108, which deals with the amendment of the Constitution, specific references to non-entrenched clauses in subsection 2 and entrenched clauses in subsection 3. Any amendment to this Constitution does not need less than 2/3 vote. Any amendment, in fact, in this case, the amendment is very clear. It's very clear. Even when you make reference to the Constitution, Mr. Speaker, when you take any wording in the Constitution, even without alteration, you reference it in another act of Parliament, it should be supported by not less than 2/3 of this House. I have had various arguments, especially the one that relates to subsection 1 of section 91, which states except where it is stated, the voting of Parliament shall be by simple majority. But in this case, the exception holds, because we are dealing with section 108, which has to do with amendment of our gun law, which is the Constitution. So, Mr. Speaker, I take the greatest exception, and we on this side take the greatest exception on the fact that this Constitution should not be amended, or no clause must be changed, or no letter must be changed, or no sign must be changed, be it in committee stage or in third reading with less than 2/3.
I'll listen to just one more position by the leader of government business, and I'll rule. Yes, leader of government. Mr. Chairman. I said probably you have more. Okay. Yes, Mr. Chairman. Then I will listen to Honorable the leader of government business. I will listen to Honorable Gepa, Honorable Daniel Kroma. Okay, then I will rule. Yes.
Mr. Chairman, based on my standing in Mr. Chairman, yes. Based on my standing in the House, I want Gepa to talk before me.
Okay, Honorable Gepa.
Yes.
Thank you, Mr. Chairman. Mr. Chairman,
listening to the honorable colleagues, this is a very crucial moment. Forget about all other tools on this side. Yeah.
Listening to the submission of the leader of government business, we all have to acknowledge that we are making law. This is not engineering. And in making law, you look at the text of the very law that guides the lawmaking that you are making. I refer you to the very section that you made reference to, section 108, subsection 2, and we read it carefully for the public to understand. Thereafter, I will take my seat. Mr. Chairman, honorable members, section 108, subsection 2, which my colleague has acknowledged, that deals with non-entrenched clauses, state thus: a bill for an act of Parliament under this section shall not be passed by Parliament unless A. Before the first reading of the bill in Parliament, the text of the bill is published in at least 2 issues of the Gazette. That has been done, provided that not less than 9 days shall elapse between the first publication of the bill in the Gazette and the second publication, and B. The bill, this is the most crucial part, the bill is supported. It did not say the clause. It did not say the clause. Take note, emphasis 9. The bill, that is the entire bill. The bill is supported on the second and third reading by the votes of not less than 2/3 of the members of parliament. My submission, Mr. Speaker, members of parliament, it is my submission that we are at the committee stage, wherein we are voting on clauses, clause by clause voting, and as such we are guided by the provisions in section 91(1) of the 1991 Constitution, which I shall read as well. Section 91 reads thus. Section 91 reads thus. Mr. Speaker, honorable members. Section 91 reads thus. Okay. Except otherwise provided in this Constitution, any question proposed for decision in Parliament shall be determined by a majority of the votes of the members of Parliament and present and voting. Majority, emphasis 9, which means simple majority. So I will emphasize again for the members of Parliament that are following, when we are voting on clauses, we are not voting on the bill holistically. When we get at the point where we have to vote on the bill, I will concede to your point that it has to be a 2/3 majority. But now that we are voting on clauses, you go by 91 because a clause and a bill are different. My submission.
Yes, Honorable Director. Honorable Director.
Thank you very much, Mr. Speaker. Mr. Speaker, before my intervention, I just want to ask a simple question to the honorable members' submission. Simple question to the honorable members' submission. The honorable member from Kailam. Just a simple question for the layman understanding and for the attention of the public, for the attention of all Sierra Leoneans in and out of this country. Just one simple question. Sierra Leone is made up of 14 districts. True or false?
14 provincial districts.
14 provincial districts. Sierra Leone comprises of 14 provincial districts. True or false? True.
Honorable members, please, let me crave your kind indulgence. This is a very serious matter. Please, I'll crave your kind indulgence. You know, when people debate on this side, and when people debate on this side, please let's pay attention so that we get the public to hear what we are saying. Please, it's a plea from me. Yes, proceed.
14 provincial districts constitute the nation of Sierra Leone. Simple question for the layman understanding. If there is border disputes in one of those districts, border disputes in one of those districts by another neighboring country, of which during that dispute, members of our district bordering that neighbor country are being killed, are being maimed, are being raped. Is it the problem of Sierra Leone or not? Let's say for instance, Kwanedugu. I came from Kwanedugu and I represent Kwanedugu. Kwanedugu borders Guinea. And Kwanedugu is part of Sierra Leone. If Kwanedugu has problem with Guinea, and then the Guineans come and bombard citizens of Kwanedugu, rape the women of Kwanedugu, kill the people of Kwanedugu, is it a problem of Sierra Leone or is it a problem of Kwanedugu?
You want to answer?
It's a rhetorical question. It's a rhetorical question. You can answer in your mind. And your conscience can answer as well. The problem of Kwanedugu is a problem of Sierra Leone. And His Excellency the President is president of Sierra Leone, of which Kwanedugu is a part. Mr. Speaker, on that premise, I refer you to section 91.1. Section 91.1. It reads, except as otherwise provided in this constitution, underline that exception clause. Except as otherwise provided in this constitution, any question proposed for decision in Parliament shall be determined by a majority of votes of the members present and voting. Mr. Speaker, you are a lawyer from no means standing, and the honorable member from Leone is a senior, and he quite well noticed that this provision, subsection 1 of section 91, has an exception clause as an opening statement. That opening statement is not for nothing. The drafters knew what they were doing by providing that exception clause. Mr. Speaker, you will also agree with me, including my senior devout, that in law, you have rules. Sometimes you call them general rule. You have general rule. And you agree with me that not all, but most of those general rules, some of those general rules has exceptions. There are exceptions to general rules. And in fact, apart from that, there's a third stage. You agree with me in the law of evidence that in addition to general rule having exceptions, you also have what we call exception to the exceptions. You have general rule, you have exceptions, and you have exception to the exceptions. Secondly, you agree with me. You agree with me that all exceptional clauses supersede the general rule. Exceptional clauses supersede the general rule. You agree with me? My senior knows that whenever you have exception, that exception is superior to the general rule. It's not affected by that general rule. It supersedes, it's more powerful, it's more superior, it's more potent than the general rule. Mr. Speaker, honorable members. Mr. Speaker, honorable members, I read the provisions of section 108. But before I read, I want to inform this House that section 108 is clearly, unambiguously an exception to section 91.1. It's one of the exceptions to section 91.1. A clear exception. It's very, very clear. Mr. Speaker, another exceptional clause in the Constitution is the law dealing with state of emergency, passing state of emergency. State of emergency gives exceptions. It gives exceptions to the powers of the president. The general rule sets limits to the powers of the president. It sets limits to the rights, the human rights of citizens and non-citizens residing in and out of this country. It sets limits. But Section 29 now came. You and I know that under Section 91, Section 29, those general rules regarding your human rights, your right of movement, your right of speech, or this and that, the exceptions supersede those ones under 29. And the president has the power to overdo his general power, stated in chapter 3. The President Order 29 has the power to overdo chapter 3 of the Constitution dealing with basic human rights. You know that very well. Mr. Speaker, clearly, Section 108 is an exception. And I read, without further ado, I read paragraph B. Paragraph B of Section 108. I will first read the opening statement. Subject to the provisions of this Constitution. Subject to the provisions of this Constitution. When you say subject to the provisions of this Constitution, you can say reference to the provisions in 91.1. Because 91.1 is part of the Constitution. Subject to that provision in 91.1. Subject to any other provision. But I will refer you to the provision in 91.1. Subject to that provision. Let us stand there and then move on. Parliament may alter this Constitution. Parliament may alter this Constitution. Of course, may. Because it is of the discretion whether to pass it or not. We have the supreme power under 105. You know that. May alter this Constitution. What constitutes alter? The verb to alter. Or the noun alteration. What do you mean by the word alteration? In this Constitution, any form of amendments, any form of changes, any form of importation from one act to this one, or taking it to another one, or taking it from one chapter to another chapter, no, it's best fit under chapter 2 rather than chapter 3. It's best fit under section 9 rather than section 1. That's importation. And even by modification it says, but it reads down this way rather than that other way. It constitutes alteration. And that alteration points to single individual clauses, single individual provisions in each clause. It says that bill, the bill before us here, the bill before us is supported by the second and third reading by the vote of not less than 2/3 of members of Parliament. Now listen. Now listen. Subsection 8 of section 108 for further edification. Subsection 8 of section 108. It reads, maybe I will only stop to the opening paragraph so that I will go to the others. Or if you don't mind, I will read all. Subsection 8 of section 108. Speaker. Mr. Speaker, honorable members, subsection 8 of section 108. It reads, any suspension, alteration, or repeal of this Constitution, other than the authority of Parliament, Thank you, Mr. Speaker. Mr. Chairman, I will start fresh. Any suspension, alteration, or repeal of this constitution other than the authority of parliament shall be deemed to be an act of treason. And I want you to pay careful attention to this one. That to suspend, to alter, to repeal, only parliament can do it. So now we are dealing with alteration. We are not suspending. We are not repealing. We are dealing with alteration. This alteration now goes, in fact, on three, goes further to say that even references alone, by just making a reference, to a particular provision of the Constitution, amounts to alteration. But I will read for education. References to this Constitution include, listen to this, references to this Constitution include references to any law that amends, replaces any of the provisions of this Constitution. I will repeat this one. References to this Constitution includes, underline the word includes references to any law that amends or replaces any of the provision of this Constitution. Mr. Speaker, without going further, when you talk about provision, a bill is not a provision. A bill cannot be described as a provision. Provision refers to individual clauses. Provision refers to individual clauses. Individual clauses. Mr. Speaker, honorable members, in fact, this one even you don't need to pass again. You don't need to pass again to understand this mathematics. Let's say the bill has 9 provisions. 9 provisions. I've told you what provision stands for. A bill cannot be referred to as a provision. Provision refers to individual clauses in the bill. Now let's say for instance, you have 10 clauses in a bill. 10 clauses in a bill. And then you say, this is for layman understanding now. You say, those bills gathered together needs 2 doors. Those 10 clauses gathered together are called a bill, are being referred to as a bill. And until it is treated as a bill, before it requires 2/3. But on the contrary, those 10 provisions, in order to pass each, you just need a simple majority. Now let's go this way. The Constitution says you need 2/3. For the 10 clauses put together, you need 2/3. And then you are saying each can go by simple majority. So let's say now we'll go to the first clause. Number 1 clause, simple majority, passed. Number 2 clause, simple majority, passed. Number 3 clause, simple majority, passed. Number 4 clause, simple majority, passed. Number 5 clause, simple majority, passed. Number 6 clause, simple majority, passed. Number 7 clause, simple majority, passed. Number 8 clause, simple majority, passed. Number 9 clause, simple majority, passed. The last and final clause, number 10, simple majority, passed. And now you all come now together. So well, from 1 to 9, you need 2/3, and then the bill cannot pass 2/3.
Thank you. Does it make sense?
Does it make sense? Does it make sense? If you can go from 1 to 10 by simple majority, and then there is another bridge to cross, and that bridge now, the law says you need 2/3, and then you cannot cross that bridge. So why waste time? It proves that that is not the intention of the drafters at all. At all. Mr. Speaker, the word passed. The word passed. Am I protected, Mr. Speaker? Thank you, sir. The word in law, passed, in quotation, passed. You know what it implies? It implies finality. It implies finality. Finality. When a bill is passed, it means it has come to completion. It is now law. That's the legal meaning of the word passed. So let me ask you this question. How can you apply the word passed to a clause? Clause 1 passed, clause 2 passed, clause 3 passed, clause 5 passed, clause 10 passed. And then all bodies together, or 10 come together, they cannot get 2/3 majority, and then it's not passed. So the word passed in law cannot apply to individual clauses. It cannot. Under section 108, the term in law passed cannot apply to individual clauses. Simple majority cannot apply to them, because under section 108 they cannot be passed in the absence of 2/3. Let me tell you one. Mr. Speaker, section 108 is so selfish. Very selfish. Selfish. I've never seen a selfish clause or a clause more selfish than section 108. Very selfish. So section 108 sees itself as so important. I am everything. Without me, you cannot live. And everything starts with me. It starts with me. Everything starts with me. Mr. Speaker. Thank you, sir. Mr. Speaker, I refer you to subsection 3. Subsection 3, paragraph A. I will read the opening subsection and then I will stop at paragraph A. Subsection 3 of section 108. Subsection 3 of section 108. Paragraph A. But I will read subsection 3 for better understanding. Say a bill for an act of parliament enacting a new constitution or altering, remember altering, any of the following provisions of this constitution. That is to say, now I will read it again because I want you to understand. Parliament enacting a new constitution, listen, or altering any of the following provisions of this constitution. That is to say, number one, this section.
So which section?
Section 108. That is to say, me. If you are given 10 oranges to share between 9 people, if you are wise, what will you do? The first orange belongs to who? Me. And then I will share the rest. The first law of nature is Section 108, respect the law of nature. Me first. And when the act says this section, number one, I mean A, paragraph A, this section, it means which section? Section 108. And Section 108, paragraph B of subsection 2 of Section 108 is part of this section. This section. And then it goes to outline the rest, the others. But it starts with this section. This section includes all of Section 108, all. And what this section says, that is why I see Section 108 as jealous. He's very jealous of himself. Once Section 108 has spoken, Section 108 doesn't want any interference, no interference. This section now says, in paragraph B, say it is supported at the second and third reading by the vote of not less than 2/3 of members of Parliament. That is part of this section. It is not part of the intent clauses with requiring referendum. No, it does not start there. It doesn't start. It started with himself first. I'm saying himself because I see Section 108 now as a human figure. Human figure jealous of himself and very selfish, and he will not tolerate anybody to tamper with what I have spoken. This section. Mr. Speaker, honorable members, in fact, this is for common sense now. For common sense. Our body is made up of so many parts. Our body is made up of so many parts. You have your hand, you have your feet, you have your stomach, you have your eyes, your heart, and the rest. At a point in time, the head, the eyes, the hands, they revolted against the stomach. They revolted. So when me as the hand, I walk, I use a pen and write, the eye says, in fact, I see, I direct you. The brain will say, in fact, I gave you the idea to modify, to make sure, to make sure it is appealing to your examiner or to your awarding contractor or to Mr. Speaker for approval. At the end of the day, when you get your salary, when you get your money, you buy food, under the stomach, enjoys everything. So they rebel. The hand says, I will no longer work. The eye says, I will no longer see. I will rebel.
Mr. Speaker, point of order, please. My colleague, please. Mr. Speaker, Mr. Speaker, I know you are the president of this world. I want all of us to be mindful of the principle of filibuster. I think that is what my colleague is doing. When a filibuster in a legislative process like this is trying to delay the process of coming to an end of a particular process. My colleague has been conjecturing.
You know, it's deliberate. You know why I'm allowing debate? It's deliberate.
No.
Because on this matter, when I rule, my ruling is going to take care of all the other clauses. So that's why I'm allowing debate. Because when I rule, that rule is going to take care of all the other clauses. So it's deliberate, please. Yes, honorable.
Mr. Chairman, for the order of this House, I will not permit. For the order of this House, and for your respect, I will not permit. I will go ahead. These parts of the body went on strike for about 4 days. On the 5th day, what happened? On the 5th day, what happened? The eyes became dim, can no longer see. The ear can no longer hear. The hand can no longer walk. The feet can no longer take the body from one place to the other. At the end of the day, they all appeal again. Say, Mr. Soma, please, we are sorry. We are sorry for what we did. We are ready to support you now. And then they supported. In the next 1 hour, the human figure started sweating profusely. And then energy reorganized. What I'm saying here, I'm making this illustration to prove to us that Section 108 is a human figure. You cannot divorce any part of the Constitution as being separate from the other. Touching one is touching all. Alteration of one clause is alteration of the Constitution. With the alteration of that clause will not only change, but the entire Constitution will no longer be the same. It will change. Mr. Speaker, the legal meaning of text, T-E-X-T. The legal meaning of text. Text include even a full stop. Even a full stop is a text. And changing a full stop to comma can change the meaning of that particular section. You agree with me? Changing a comma, changing a full stop, removing the full stop, and replacing it with comma can change the intent of the drafters of that constitution. It can change the overall meaning. Will change. Automatic. Even the beginner students will know that this particular clause does not mean the way it used to be. Based on the change of that text from full stop to comma. Mr. Chairman, honorable members, in my final submission, I'll present to this House that the bill before us is a package. The bill before us is a package. What do you mean by the word package? Package is a combination or inclusion or constitution of various segments. Various segments come together and form a package. If one of that segments is removed from the package is no longer the same. I don't know anybody here who used to smoke. I don't know anybody here who used to smoke. Or who smokes as I speak. But for those who used to smoke, or who smoke right now, in my days, we used to call a cigarette package Western. That Western, it has 24 segments in the packet. 24 in the packet. 24 in the packet. You remove one stick from that package, it's no longer a food package. Can no longer be referred to as a package. It's not. If one is cut into half, one cigarette stick in that package is cut into half and then inserted again with half, the rest full stick, the one half stick, it's no longer a package because the package has been altered. Mr. Speaker, above all, we are here speaking our minds, speaking of what we know for posterity. And if we are 200 in this well, I want to inform you that there's a 201 person. There's another person that constitutes also 201, and that is who? Almighty God. Almighty God is here listening. And that's what we want, God in us. God in us. You have God in you, your conscience. Our conscience knows very well that section 108, paragraph B of subsection 2 of section 108 cannot refer to clauses to be dealt with by simple majority. No. Each clause amounts to alteration of the Constitution and must need to be done. In the absence of which, Parliament may be abusing the powers given to it under subsection 8 of section 108. Because section 108 excludes all other walks of life, all walks of life. Only Parliament has the power to alter, to suspend, to import, to modify, to even make reference. So if we use that privilege given to us by subsection 8 of section 108 and misinterpret paragraph B of subsection 2 of section 108, it amounts to abuse of office. And it can even amount to treason as well. We cannot misinterpret, otherwise it will go against subsection 8 of section 108. Mr. Speaker, on that note, I must say that we on this side, we are for the Constitution. And we are not supporting any undue procedure that will misinterpret the provisions of section 108. The people of this country are listening to us, and they all support the true meaning of this particular provision. And it allows 2/3 majority to change anything. Otherwise, anybody can wake up one day and then just change anything with no issues. It will be easily abused by allowing simple majority. Simple majority can never apply to this section. And when I say this section, I mean section 108. This section applies to all, not to segment. And that's my case for that.
And then give my ruling on this matter.
Thank you. I've listened to my colleague on the other side, the Deputy Leader of Government Business, and the Deputy Leader of the Opposition, and I'm happy he happens to be a lawyer, and he's a long-winded lawyer, but I'm sure during the course of this process, he has not been paying attention. If he has been paying attention, he would realize and he called. I am not attacking him, I'm just saying, please, you said a lot of things, please, today's not the day, please, today's not the day. Not paying attention is not an insult, it's not an abuse.
The Honorable Kalem made some statements, but I said for your respect, let us respect you. You think I cannot I cannot respond. Something came in my mind. In fact, that's what. But I said for your respect, I will respect you. That is it will get it, there's one for us. And then that's my respect for you.
Thank you very much, Honorable Nkrumah. Remember, let's be careful. Let's guide our words.
Mr. Chairman, I will still stand by my words. I know not paying attention is not an insult. Not paying attention is not being attentive. Period. And this House will recall that in the course of the passage or the review of this bill, when we discussed Section 76, myself and the leader of the opposition, we were against the extension or the enactment of 12 months as the period specified in this constitution for a civil servant or anybody prescribed by this constitution to resign. However, Mr. Chairman, you asked for a vote and we voted, and in that vote we were defeated by simple majority and a ruling was made by Mr. Speaker. Mr. Chairman, I have said this process is bent or depends on the fact that we have to be honest. This is the Constitution. The other document is a proposal, a bill, which is not the Constitution as provided for in Section 108. A proposal before Parliament can never alter this Constitution, whether it is dealt with clause by clause or not in the committee stage. It will never change the intent, spirit, and purpose of this Constitution until it gets to the third reading. Mr. Chairman, how can a proposal be treated, and he has read, and I'm sure he understands subject, verb, argument, he understands the subject, the predicate, and all. So he should understand the fact that the emphasis on paragraph B and the very subsection 2 of section 108 starts with the word the bill or a bill. How can a simple clause that is not in this Constitution, that is a proposal that is presented before this House, end up as a factor to change this Constitution before it's started? It's never possible. So the drafters of this Constitution, they knew that the fact is you can do anything at any stage, but at the third reading, before it has the mandate of Parliament as provided for by subsection 1 of section 108, that Parliament may alter it. Before Parliament alter it, it must have the consent of 2/3 of members of Parliament at the third reading before it is passed into law. But how can a proposal at this committee stage form part of the bill? I heard him say that if you take a stick of Western, by the way, those of you who are very young, it's white packet, it has a horse, it has red background. My mother was selling cigarettes. I heard his description of Western, and I will also draw his attention to two examples. The first is those that attended Jala University will tell you that they will sit in the first year, in the second year, and in the third year, but they will never get a degree until they pass the comprehensive examination. Mr. Chairman, those who are teachers and those who start to the NCTV exams before they have the opportunity of going to college, I'm sure somebody is there. You will pass all of your exams at Mitulagai or whichever of the NCTV constituent colleges, but you will not have the NCTV certificate that will qualify you for an application for any university until you pass the comprehensive NCTV exam. So if he's talking about common sense, I think common sense should apply pari passu. Common sense should apply pari passu that a clause that is not in this Constitution, that is a proposal brought to us by a minister of government, can never enter or have its way in this Constitution until after the third reading, Parliament takes the vote of 2/3 on the bill as provided by section 108. So for me, I see this long-winded, skewed conversation as a way to try to play to the gallery. And we have passed that. We have been on radios, public radios, national television. We have taken a debate. At the magnanimity of Mr. Speaker, even during the committee stage when we are discussing clause by clause, you allow a debate also to ensue. I think that is sufficient. And Mr. Chairman, this House will continue to rely on a source of law, which is President. And the President has been taken on this bill. We have voted on a clause that forms part of this proposal. And that clause will not pass until in the third reading it is voted for by 2/3 of members of Parliament. That is when that clause that was proposed during the second reading would become a law for this country. Mr. Chairman, we rely on your wisdom and we want to progress so that we complete this process as fast as possible.
Mr. Speaker, honorable members, I can't really understand this problem. What is before us is a bill. Mr. Speaker, what is actually before us is a bill. For you to pass, I am not going to read the provisions. You know, Mr. Speaker, I guess you read jurisprudence, Jurisprudence, you read that one. It's the logic, the origin, and the underlying theories of the legal systems. That is jurisprudence. I was at private college, I was a law student. It's a very difficult subject. I mean, that's why it's difficult to pass. I know that Mr. Thompson is around, and Dr. Wright. I know they are around. He must be watching us. Oh, Doc is here. Mr. Thompson, you are here. And Ronald Wright will be watching us. The man who used to admire. I did some logic. In composition of a sentence, you have a word. The word constitutes what you call sentence. And sentences, when you constitute them, makes up what you have a clause. And those clauses make up sections. Those sections formulate to have what you call a bill. Simple. So science of philosophy is what we call jurisprudence. Science of philosophy. Science of philosophy. So I'm thinking that the interpretation, going around, merry-go-round, interpreting this, going through this, we are not new. It's not the first time we are amending this constitution. We have done it, simple majority, at the committee stage, clause by clause. Mr. Chairman, it's very clear to us, in this famous section 108 you are quoting, trying to confuse people, we cannot be convoluted with this whole thing. We can't. We can't allow you to confuse us. As I said, I know where they are coming from. And I see them giving us their backs at the end of the ruling. This has to do with the future of this country. Bill is what we have. We are continuing to pass it. We said, for you to pass this one, the bill, it is a bill. The topic is bill. It has to take 2/3. We have done collection of voices in the second reading. We are now at the committee stage. We are now approaching the third stage where you are going to put questions, we do division, and we come now to vote to get 2/3. For clauses, they are explaining. It's 91, simple majority. We have done this times without number, over and over. Sometimes these lectures can be very unpalatable to us. When you may go around without making a logical conclusion, you have failed jurisprudence. You have failed jurisprudence. Mr. Chairman, for us on this other side, I still sustain our position. And people are explaining sincerity of the law. We have to express that one. This 32 we are talking about for the consultations, for this, we want the instant provision to be maintained. That is the provision they agreed in June 17, 2017. That was agreed upon by late Justice Kawan's report, white paper. We have it here. You all know. We have debated over and over. So we are not filibustering here. We just want the people to understand. And what we are doing is not the origin. That's why I said jurisprudence. The origin. It's not coming from us. It's not coming from President Liu. It's coming from the former administration and also the late Pakaba of blessed memory. What we are doing, we want to put finality to this process. So I don't think if you are teaching law subjects and simple English,
this is written B. And we said, I said, all budget is fine. Clauses constitute what you call, put it into sections. Sections, all of this makes up a bill. So we are sanitizing this bill. But when you want to pass it into law, all this issue of alteration, no alteration, for now, it doesn't make sense. If you don't take the 2/3, it's no law. If you don't take the 2/3, it's no law. So, when we cleanse or sanitize the clause by clause, we are going to put a section to these sections, and you put a final question. That is why, even in the 2/3, you have to claim division. When we are at the second reading, you put a question, and we did collection of voices. No dissenting view. That is 46, and you have claimed 46. It's not a bill. We said clause. If you are talking about the bill, you should are talking about let us vote directly. We cannot underscore the integrity of anybody, but let us make some sense out of our submissions, or out of what we have in front of us. So, Mr. Speaker, as Honorable Deputy Speaker said, we don't want people to play to the gallery as if we don't know what we have debated for so long. I will stand here and speak over and over, but we want to put a logical conclusion to this business, to make sure that what we have in front of us, for now, it deals with simple majority based on passing the particular committee, the clauses we have in form of simple majority. We have stated all the provisions. I repeat myself where I take my seat. 108 says 2/3 for the collection of the bill for second reading and third reading. The bill, it said cannot pass it if you don't have the 2/3 majority. What we are doing now is the clauses we are amending, and the clauses have to do with 91. This is not the first time. If they doubt it, I also encourage them to invoke SO12 hands out. I'm not new to these things. We have dealt with them. Amendment of PPLC Act. We did amend clause by clause of this constitution. Let's go to the answer. That's why we have the records. President, you have amended this constitution in the 4th Parliament using collection of voices, even when people had dissenting view. The man you call to the assembly, with all due respect to him, SBB and Honorable Chairman Manjubadi are all seated here as Deputy Speaker. They passed an amendment. The election of Speaker and Deputy Speaker, a collection of voices. When you be the hard, Salim, 79. We don't want to go 79. We don't want to go to the Hansard. But Mr. Speaker, Mr. Chairman, we are watching. What you are putting to the fore of this country is our sincerity of document we have presented to this House. That June 2017, we all accepted to sustain this provision, Section 32.3. that has to do with consultations of appointing electoral commissioners. Thank you, Mr. Chairman. Thank you for the rest.
Honorable members, I'm going to take my time to explain the reason for my ruling. I will take my time to explain so that everybody is able to understand the reason why I will rule in a particular way. Please, we are all members of Parliament. Please take your constitution and turn to 91. Section 91, subsection 1 reads, Honorable members, in fact, this particular section is not even written in serious legalese. It's written in plain language for all of us to understand. There isn't much legalese here. 91 subsection 1 reads, except, it starts with the exception, except as otherwise provided in this Constitution. Except the Constitution says otherwise. Except this Constitution says otherwise. Any question proposed for decision in Parliament shall be determined by a majority of the votes of the members present and voting. So everything we do in Parliament, all the decisions we arrive at in Parliament, except this Constitution says otherwise, will be by majority of the members present and voting. Now, because this particular section refers to an exception, I will tell you that there are exceptions in this Constitution. Now turn to section 29, subsection 3. Turn to section 29, subsection 3. Section 29, subsection 3, particularly B, but I will read the entire section. Every declaration made under subsection 1 shall lapse. A, I'm not bothered about A, but B. In any other case, sorry. Okay, in any other case, at the expiration of a period of 21 days, beginning with the date of the declaration, unless it has in the meantime been approved by or superseded by a resolution of Parliament, supported by the votes of 2/3 of the members of Parliament. That's one of the exceptions. One of the exceptions. You know, 91 subsection 1 says except. So one of the exceptions referred to in this Constitution is 29 subsection 3B. Now turn to section 119 subsection 9.
For the votes and proceedings. The references, I know the references. Maybe know the references.
Now, in section 119, subsection 9, honorable members, let me read. It says, the provisions of section 137 of this Constitution relating to the removal of a judge of the Superior Court of Judicature other than the Chief Justice from office shall apply to the Auditor General. Now, in this 119 subsection 9, reference is made to section 137. Go to section 137. Yes. Now, particularly subsection 7. Now, 137 subsection 7 reads, a judge of the Superior Court of Judicature shall be removed from office by the President if the question of his removal from office has been referred to a tribunal appointed under subsection 5 and the tribunal has recommended to the President that he ought to be removed from office. B, if his removal has been approved by a 2/3 majority in Parliament. That is another exception, tied up to section 119, subsection 9. There's another exception, section 137, subsection 10. Go to that provision again. Now, section 137, subsection 10 reads, the Chief Justice shall be removed from office by the President. Now, A says something. B, if his removal has been approved by 2/3 majority in Parliament. I will also refer you to section 173. Go to section 173. Now, Section 173 reads, now the provisions, I'll take my time to read, the provisions of any consequential provision act made under this constitution and of any act relating to citizenship. Another exception is 108. Go to 108. Now go to 108. Now 108, subsection 2, particularly paragraph B. The bill is supported on the third and the second and third reading by the votes of not less than 2/3 of the members of Parliament. Now, you see the law, especially codified laws that are written, you don't perceive them. You don't create your own perceptions about the law. Codified laws that are written, when the drafters want to say anything, they write it. I sense a whole lot of confusion about the Constitution. But when we come to the third reading of this Constitution, I will do a ruling. And that ruling will be referred to the Supreme Court for opinion. You don't create perceptions about the law. If the drafters mean anything, they write it. So apart from all of these exceptions, any decision we want to arrive at in Parliament is by the majority of those present and voting. All those now, honorable members, that being said, let me also refer you to the fact that this document we have before us, of course, the Deputy Speaker went to a very large extent to speak my mind. This document we have before us is not the Constitution. Because I sense a whole lot of confusion around this. It is not the Constitution. This document is not the Constitution. And this document we have is what we call a proposed law. It is a proposed law. And whatever we do in this document, line by line, clause by clause, does not affect the Constitution in any way. The only time this document is going to affect the Constitution is after it would have passed the third reading. Then all the provisions there come into play automatically. The day we pass the third reading of this document, that is when all the provisions in this document come into play. Otherwise, this is just a proposed law. It's just a proposal. This document is just a proposal. You know, the drafters were crafty enough. They were so crafty. They know one important stage of this document is the second reading. Because after the second reading, then you go to looking at the bill, clause by clause, line by line, paragraph by paragraph. And they know at the third reading, then it becomes law. By dealing with any clause here, does not mean we are amending, we are repealing, we are replacing any provision. In the first place, this one we just dealt with is not even in the Constitution of Sierra Leone. This such a nomination committee is not even in the Constitution of Sierra Leone. So you can't even begin to talk about 2/3 on something that is not even in the Constitution. In the circumstances, honorable members, I rule that our decision, clause by clause, will be by the majority present and voting. Yes, leader of the opposition.
I so much respect you as a person. And my position has always been that we are living a lasting memory as a nation. This parliament is making the history. And we on this side, totally convinced, we are extremely persuaded that you cannot change east to worse and off to art in this constitution by mere simple majority. With every respect to your ruling, sir, as stated in SO 42, I want you and the general public, the entire world, to note that we on the side will not be a party to advocating or going against the standard amendment. We have supported various reforms brought to this house. If we are not willing to support reforms, we will never have voted today. But what we did was an expression of our total willingness for government. But our willingness does not mean we should do what we consider as unlawful. So, Mr. Speaker, with all due respect, sir, pending on your ruling, we want the entire world to note that 96 honorable members of parliament are seeking to amend a document that is to be amended by 100 members of parliament. So we on this side cannot be a party to that, Mr. Speaker. So honorably, sir, with all due respect, sir, I respect your office so much. I respect your office so much. And in fact, I am constrained because of the respect I have for your office. We on this side will honorably, with all due respect to your seat and with all due respect to this parliament, and the people of Sierra Leone who are watching us, people all over the world, we on this side will not be part of an amendment that lacks the threshold of 2/3 majority. So on that note, we are leaving the ball in your court. 96 members. If you want to touch the constitution, you have the army for posterity.
No problem.
Posterity will hold you responsible. So on that note, I ask my colleagues on the side that we take a peaceful leave and leave the 96
I just wanted to inform you that yes, sir. The sitting is being disrupted a little. Yes, sir. At least you. Yes, sir. Yes, thank you.
Let's listen to yes. Carry on. Okay. So we are going to start.
It's all right. Honorable members, please occupy your seats. Occupy your seats. I'm going to be ruling on this subject. And I'll refer the matter to the Supreme Court for opinion. Can we proceed with the other clauses? Proceed with the other clauses.
Mr. Chairman,
Yes.
Mr. Chairman, so
go to the age thing on page 3.
Yes, page 3 on the age. I think the aging made the proposal during the debate. Order, please.
Order.
Mr. Chairman, however, we have moved the age attached to those qualification. I said, if we are putting a term of 2 years, of 2 terms, you should only qualify to be a commissioner if you attain the age of 65. If you attain the age of 65. We cannot use 2 bars in most legislations in conformities with the law for us to put two bars at the same time for one provision. So I'm moving at instead of we said he has not attained the age of 65 years, running down to B of that one. If he has not attained same provision under the member of the Electoral Commission, unless he has attained the age of 65. So we are saying,
okay, we leave it as it is.
You cannot be qualified. I have done 2 submissions.
So what do you
can only qualify to be a commissioner if you have attained the age of 65. That is one. But we are now, I'm going to introduce another clause.
Yes.
That you have a term limit.
A term limit
of 2 years.
Of 2.
Yes. So and now
take note, Mr. Minister.
Mr. Minister,
can you move? Can you move?
Yes. To move that you cannot be qualified to be a commissioner if you attain the age of 65. That is one. That will come the rendition.
The rendition will be done properly. Any seconder? Any seconder?
I so second, Mr. Speaker.
All those in favor say aye. Aye. Those against say nay. The ayes have it. We proceed on page 4.
Mr. Chairman.
Yes.
We give you the rendition for. I want you to be consistent with other provisions like we have for chairman.
We have just passed it. We have just allowed it in principle.
In principle.
Yes.
So we come back to other rendition and we pass it.
Yes. Proceed. Proceed. Page 4.
Dear Speaker.
And okay, on page 3, there was this provision relating to if he is not a member of a registered political party. Are you maintaining that? If he is not a member of a registered political party.
That goes no harm. We put it just to enhance the process of legislation to qualify, yes, registered. What I think we have to do, because there is a clause at the PLC Act that has to do with a registered political party and an active political member. So we are going to put a registered political party. We will check that one with the drafter. Thank God the drafter is here. Okay. Because they are speaking in 2 different languages. So at a registered political party, I think we consult the drafter and we'll come back to that. But definitely we have to state it. Yeah, thank you.
Yes, Mr. Minister. Is that correct?
Yes, Mr. Speaker, honorable members.
Yes. Again, whilst I agree, Mr. Chairman, I'll kindly agree with the Honorable Leader of Government Business. Whilst we're looking at that particular rendition, we also consider, because sometimes it's difficult for you to even prove membership, we can talk about engagement in partisan activities.
Okay. Is all right. Is that noted, honorable members? Okay. Yes, page 4.
No, yes, Chairman, I was expecting, Mr. Minister, we agree that if the masters for the qualification that if you have a postgraduate from a recognized university and has, that is 3, a Chief Electoral Commissioner, unless he holds a postgraduate degree from a recognized university, 1, woman 2, has a professional qualification and experience in governance and public sector, at least for the Chief Electoral, at least 5 years.
Yes, we did that amendment.
We did that amendment,
yes,
right?
10 years or no?
Yeah. Is it 10?
The others are 5 years.
No, the others are 5. And also for the bachelor degree, when you talk about postgraduate course in the Chief Electoral Commissioner, you can act in that capacity at any time. So why not just say the same qualification for the Electoral Commissioner? For B, the Electoral Commission, unless he holds a bachelor degree of equivalent from a recognized, I think I want to be consistent with the law. For the SPSS, the qualification for the National Security Act, there was a difference in qualification with that of the NS score and deputies, even for CISA. So we said no. You can act in that position at any time. For the experience as you have done here, I can understand. But because you are going to act and that has to do with some level of efficiency and professionalism, I believe that that has to come to the level of qualification, that's what degree. I think they should have a say for consistency sake in enacting the law. Okay. That has been my position from the first day I made my submission to the House.
And under clause 3, we were supposed to have inserted 61. Amendment of 61.
Mr. Chairman.
Yes.
Mr. Chairman.
Yes.
Yes, I just want to make a quick comment on the recognized university aspect. Yes. So I don't know, there are some universities that are recognized, but then they are not accredited. So I don't know whether we say accredited or just recognized university.
Honorable member, before the chairman comes in, I don't think this is something we have to belabor on because we've had provisions that clearly spells out when it comes to the qualification in terms of how we use that particular aspect when it comes to universities. I don't think that will be a problem. Thank you.
Honorable members, I think we don't need to engage in further debates. Let's go to the issues as they are, because I don't think there is much contention right now. We just go to the issues and move.
Mr. Chairman, let's be honest. Let's just put this clear. We have legislations already existing for different institutions. They are part of. We have to understand, so we cannot come back to it.
Of course.
We cannot do the administration of the law.
Of course.
That is why we have other subsidiary legislations. But there is a reason I asked the minister for 108 in terms of fixed election dates. He made a pronouncement that yes, subsequently those legislation will be in front of all the PLC Act, the Public Elections Act, and also with the provision for the for regulations. So those things have been taken care of. The University Acts are there. Whether you are accredited, there's a whole lot of criteria you have to go through for it to be recognized as whether recognized university or not. What we are interested in, when we are doing our vetting, we now ask the relevant institution to prove to us whether you're coming from a recognized university or whether it's not no more university which you can accommodate. So those things can be there to see. Thank you.
So we are on page 5, not so?
Alright, okay, I can.
No, of course, that one goes through. The rendition will now be done. As long as we've agreed in principle. Page 4, page 5.
Well, in page 4, you know, the other day we discussed the issue of staggering when it comes to appointment. But the essence of that was not to allow the appointment to commence at the same time, to ensure institutional.
We agree.
Yes, but what's not clear, I think the terms. It came up. You know, yes, a commissioner shall serve a full term of 5 years from the date of appointment, irrespective of the remaining terms of other commissioners. That's the end of it. There is nowhere that talks about even reappointment. It's only a term of 5 years. So again,
that can be started by proper.
Yes, again, because we've had that for another term of 5 years, like normally you understand reappointment.
Okay. That is on 4 also. Mr. Minister, take note of all of these issues.
Yeah, Mr. Speaker, I'd like to make some correction or something.
AG, before, in fact, my attention has been drawn to by the clerk that it was even inserted on that page.
Yes, certainly.
Thank you.
Certainly, Mr. Minister. So we proceed to page 5.
Mr. Speaker, before we proceed to page 5, with your leave, because of the modifications that have been made, section 32, subsection 4, we propose that some rewarding is done, especially relating to the age of 65 years. And what I've gathered from honorable members, the intent is that if someone has attained the age of 65, then that person is not qualified to be appointed. Emphasis on the word appointed. Chief Electoral Commissioner. However, based on the submission that has been made and as approved by members of Parliament, if someone is already appointed for a term, and then in the course of that term, that person turns 65, he will still continue to hold that office until he or she finishes that term. Because the reading of it now, B, says a person shall not be qualified, B, to hold office as a member of the Electoral Commission, of the Electoral Commission, if he is a minister, deputy minister, member of Parliament, or a public officer, or if he has attained the age of 65 years. So which means, if under current law, if you turn 65 while serving on the commission, you cease to qualify immediately. So the proposal will be for section 4 of section 32 to read, a person shall not be qualified for appointment as a member of the Electoral Commission, A, if he is not qualified to be elected as a member of Parliament, and B, if he is a minister, deputy minister, a member of Parliament, a public officer, or if he has attained the age of 65. So that way, that restriction, when you're 65, applies to appointment, not service. That would be the amendment, Mr. Justice.
Yes, Mr. Chairman. So in that case, the issue of reappointment for such a person is null and void.
Are we set on that?
Yes.
Thank you. Are we set? Yes. Mr. Minister.
Yes, Mr. Speaker, we have taken note of the correction. We just wanted to provide that clarification.
Okay, sorry. Yes, so we move on to page 5 also. Page 5.
I think in page 5, it's the subsection 2 was where we stopped. Which, of course, I strongly believe the leader
On page 5? No, we don't have 2 on page 5.
Or B, I mean B, the B aspect.
Mr. Speaker, if I may,
it's the B aspect.
Oh, yes, no.
Mr. Chairman. Exactly.
Yes. Yes. So it's
Yes.
Yes.
Thank you. And under clause 3, I think we changed 2 to 1.
Yes.
We changed 2 to 1
instead of subsection 2.
I think under the proviso, we did an amendment by the insertion of 61 or 61 or something like that. Am I clear on that?
Mr. Chairman, first, let us do an amendment for the 30%. Let us get a proper rendition, but we all accepted that we should have the 30% as enshrined in the Kiwi Act. So we should just input that one.
Yes, and I think there is something related to the executive. Not
yes, so we are here to have the minister.
You have to guide us.
Yes. Yes,
just a minute, let me come. We need to have it in the proper order. This one has to do with elections. This one has to do with electoral laws. Yeah. The one that has to do with the executive, we are saying we place it where we have 61. So it should be in the next page. It should be the other page. So for this we sustain 30% as the Human Act. Okay. So the thing I want the minister to clarify is he going to carry the word shall as proposed?
Yes, Mr. Honorable Members, for
we still want to have you on that.
For section 35, we will keep the word shall, and for section 61, it will be made.
Okay. Okay.
So the submission.
That's on page 5.
Yeah. So your submission is still in line. Is still in line with only the 30% party nominees for national and local government elections shall be women.
Correct.
So the subsequent provisions in the Public Elections Act remain the same. We don't touch that one at all. We don't import them. You know?
Well, yes. The only thing is, when we get to that, we will propose an amendment to section 58 of the Public Elections Act.
So we don't need to go far. So if you accept this one, we now go to Public Elections Act and do the subsequent amendment, because you have said, I also tell us to seek in line with section 58 of the Public Elections Act. So here we maintain the word shall, Mr. Chairman, and we rely on the Public Elections Act to entrench to make a clarification in section 58.
Right.
Okay. All right.
So is that noted?
Yes, sir.
Then we move on to page 6.
Mr. Chairman, please.
Yes.
I'm not a lawyer, I'm a lawmaker. I just want some clarification.
Yes.
It's simple. One person representing. What is the difference between the two? When can the president appoint without making reference to any group? One person from.
Where is that?
Just this.
Well,
Chairman, I think he's talking about his search. Yes.
No, we are
On page 5.
No, we are done with that.
Mention the language I'm talking about.
No, forget about the language.
Okay. Thank you.
There is no way I intend to be a doctor.
Once again, there are certain areas where they agreed on, so you understand, no need to be open. Just like we draw our attention to the areas where we stop things, and those areas have been highlighted.
Yes, page 6. Mr. Chairman, sorry sir, I beg to differ. Those questions are not. Those questions were agreed on principles. So what we need to do for the edification of the public, we have brought in all of those provisions. We seemingly agree, but it has no force of law. So we have to state it.
Yes.
Especially they have worked out that we agree on those provisions, on principles. So what you are doing now, we are taking our time to go close my God, you stop keeping on them.
Yes.
So we have dealt with all of them that we 61.
Yes.
Making term limit for electoral commissioner. And what you are proposing, I will say, attend it because we say you cannot put two back. The qualification should be the same. And the year of 10 years and 5 years. I remember
yes.
We agree on those things. Right? So we have to go over it so that people understand we agree on them.
Of course. So page 5 to 6. Page 5 to 6.
Page 5 to 6. There is an area, the top part of that's section 4. The A and B, there we stock things. The C and D that had to do with the census, we are finding that. So it was the A and B aspect that we are going to look at, because we're talking about the aging as well, talking about moving the constituencies in such a relation aspect. The A and B, those are the areas that we stock people.
So are we okay now with that? Because there's no more contention. You don't have much contention. So are you okay with that? Leader of government business?
Yeah.
To 6.
Yes, I'm working.
So those provisions stay?
Yes.
Okay. Mr. Minister, the provisions stay, not so?
Yes. Yes.
Page 6, page 7. We deleted the independent candidate, not so? Yes. And okay, so we are done with page 7. Page 8.
Well, it's clear that in page 8, E, that's where we have the issue of the treasury.
Yes, the treasury. Yes. But there is no more contention.
Well, the issue.
Mr. Speaker, I'd just like to clarify. I think we made clear and as well that yes, in the bill, we had made a proposal for a threshold of a simple majority of total valid votes cast throughout Sierra Leone, and then to a minimum 20% of the total valid votes cast in at least 2/3 of the districts of Sierra Leone.
But I think you agreed on.
Yes. Yes, I just wanted to make clear to everyone including listening public, that we are agreed with the technical committee made up of the APC and government of Sierra Leone that the amended bill on the floor of this house is to read that a person shall not be declared elected president of Sierra Leone unless at the presidential election he obtains a vote of 50% plus 1 of the total valid votes cast.
50% plus 1?
Yes.
Okay.
Of the total valid votes cast. So, and that removes the threshold and the simple majority.
So 50 plus 1?
Plus 1, yes. 50 plus 1.
Mr. Chairman, this is in line with the tripartite recommendation.
Hold on.
Yes. Chairman, so the one we have in the bill, and we have the tripartite, and this is in line with the white paper in June 2017. More than 50%. Everything is in line. So what we are seeing now, because tripartite is so recent and it's in conformity with most of the provisions,
So we forget about the threshold, district threshold, and stick to 50+1. Now let me be a little case for the public. If you go to section 42E of the Constitution, the first phase, the proposal we have, what is the extant provision, is 55%. And if there is a runoff, there is a runoff. F of that provision, section 42, subsection 2F, saying it's going to be simple majority in 14 days, because you do elections in 14 days with simple majority. So there is not really much difference, I see. But this one is more entrenched, it's more classified in terms of reaching out to other political parties. So some of us will receive another provision from DPR, from APA, that there is a situation where you will not get the 50+1. What happens? So we are saying for national inclusivity, because we have argued on that
of course, if the law says 50+1, if you can't get 50+1, then you do runoff. Then there's runoff.
So in the case where,
and in runoff, the one who scores the highest wins.
It is simple majority. So there is a proposal also that instead of going around doing runoff, what about making a coalition with other parties that will give you 50+1? Yes, so you should not do runoff. That was the proposal from the APA, from all political parties. That was the proposal. So if the AG, so we need to discuss it. Mr. Chairman,
yes.
Then the proposal from APA.
AG.
So if this house says,
is it not 50+1, and in the event no political party scores the 50+1, there will be runoff. Yes.
Yeah, and Mr. Chairman, repeating this particular section by bringing in the tripartite recommendation, fair enough. We realize that tripartite recommendation, both parties were there, and the presence also of international community. To be very fair enough, if we import tripartite recommendation to this bill now, and by repealing this today, I think we will join the rest of the world. The entire ECOWAS, as a member of ECOWAS Parliament, I realized that right in this supplementary act, Article 40, subsection 2, is saying countries should endeavor to have uniform laws. I think it is only Sierra Leone that is still going with 55% to make a president. But all of the ECOWAS countries, do your research, they are all 50.1 or simple majority. In fact, to the extent of even AU, 54 countries comprising the AU, all of those AU countries, they practice 50.1 or simple majority. So repealing this age-long draconic law today will help Sierra Leone to join the rest of the world. I so submit.
Yes, proceed.
Mr. Chairman, I also just want to clarify that with this proposal, and of course adopting what the leader of government said, so this proposal, just to be clear, that yes, the 50+1 threshold, which will read, no person shall be elected as president of Sierra Leone unless at the presidential election he has pulled a total of 50 plus a minimum, not less than 50 plus 50% plus 1 of the valid votes in his favor. And so the threshold which we see under 2 of that clause will go away completely.
Of course, we have stated that.
And
I think what the leader wants to know is in the event nobody scores 50 minus 1.
The
That regulation
government
has to be done.
The government's position on this for now is in the default of a candidate being duly elected under the provision that I just read, the two candidates with the highest number of numbers of votes shall go forward to the runoff.
More realistic.
All those in favor say aye. Aye. Those against say nay. The ayes have it. Proceed. Page 9.
Mr. Chairman, just for neatness of proceedings, it's just clear that this aspect, the bottom part of page 8, way to the top part of page 11, we agreed to take all of that to the public elections.
That is very correct, Mr. Speaker.
Yes, all of that. Yes, we take all of that. So that should be the bottom part of page 8, page 9, page 10, not so?
To the top part of
page 11.
Just above clause 8.
Yes, we agree. Okay, thank you. Now, the remaining part of page 11. Yes, under this one, we said to which the state is imparting. But we decided to remove that to say any criminal.
Yes, to delete that aspect to which the state is imparting.
No, not the state. We remove that aspect.
Yes, that's what I'm saying.
And we made it general.
Yes, sir.
Mr. Minister, take note of that. That's for page 11.
The text of this one that you are seeing.
We said in 43, in the event that the presidential candidate is standing trial on a criminal charge, you delete to which the state is a party. Delete that one, to which the state is a party on a criminal charge 1 year prior to the election. So we just delete that. So it becomes general, whether private or state prosecution.
So we have to set trial be suspended.
Yes.
After.
Yes, after. 1 year after. That's for page 11. Page 12.
Mr. Chairman.
Yes.
Yeah, just a clarification. So this goes for purely presidential candidate, not their candidates.
Of course.
Fine.
Yes, page 12.
Page 12, remember the top part of page 12, which has to B, was deleted.
Yes, this one was deleted. Delete?
Yes, the top part, yes. And also,
we deleted 10.
In fact, 10 was the transitional provision, and we deleted 10 to the top part of page 13.
And we deleted president or.
Yes, because that provision has to do with the vice president, so the word president there was redundant.
Yes. Then under 12E, we deleted expulsion.
Expulsion was replaced with his removal.
So under clause 13?
Well, 13 at some point had a contention for some reason. Again, we can go back again to the age we stock a pin on clause 13.
Yes, on 13. AG. We have dealt with that. Yeah, we have dealt with that. Yes, AG, 13.
Sorry, Mr. Speaker. Can you please go over that? Can you please go over that?
Well, I was saying.
There was contention on the proportional representation.
Yes, that was plus 13. That was the only area where we stuck a pin. Yes. The other areas had to do with the removal of the vice president, but the president was inserted and we deleted president.
Yes, we deleted.
Yes,
no, we are on clause 13.
So yes, I'm just taking it through it.
Yes, Speaker. Yes, we keep the proposal to amend section 74 of the Constitution to read B, such number of members of Parliament as Parliament may prescribe who subject to this constitution, shall be elected through a system of proportional representation. And then we have included an additional link to say, with a detailed mode, method of nomination and conduct of such elections prescribed by or under an act of parliament. And Mr. Speaker, with your leave, I'd like to just provide some context on that.
Yes, please.
That additional link. Yeah, that is what. But that is what.
Well, of course.
No, so
then what do you need to explain now?
You are going to bring us.
What do you need to explain?
So I'm just trying to provide. So of course we want to keep the link of that. The detailed mode and method of nomination be prescribed in a separate legislation. I think we're on the same page on that. I just wanted to say, if required, I'm happy to provide context on why we recommend that. But if members of parliament, already have the context that such prescription will be made in a separate law, and we will have a conversation on such proposals. We are happy to lead the conversation at that.
Yes. So on page 14, page 15.
Mr. Chairman, on page 14.
Yes.
We struck a small appeal.
Well,
in the sense that we have to agree on the safeguards.
Yes, the safeguards. Have you done the regulation for the safeguards?
Well, to some point.
Yes.
Because
read them out.
One, with regards, we have to agree on something because it will affect changes in some other areas, which we have to look at. Thank God Mr. Thompson is coming. At some point, we'll have to revisit 41. We'll have to revisit 54 because 41, the qualification for president, 54, the qualification for president, also on that particular aspect, then 56 to 60 ministers, then 75 to 77 members of parliament. And then, to some extent, even if possible, the Citizenship Act was to be fought for a consequential. So, now, we're going to settle on something because it's going to be clear that certain positions, which were already clear on that day, the president, the vice president, the speaker, the chief justice, those areas are prevented from that particular change. So, let me read something as part of the safeguards. A person who is a dual citizen shall have been ordinarily resident in Sierra Leone for a period of not less than 24 months, immediately preceding the date of nomination for appointment. Other safeguards, we talk about NACIT. And then also on that day, I also raised the issue of disclosure of all foreign citizenship, which was very important because if we consider here as a dual citizen, we must know the other nationality which we held again. Of course, disclose any foreign public office.
I hope Mr. AD, you are taking note. And Mr. Thompson is here also. Take note of all of those issues.
Yes, Mr. Speaker, we did take note of all of those, and I think we are on the same page.
Yeah, do a proper rendition to reflect that.
And Mr. Chairman,
yes.
As you have reviewed that, he made a lot of proposals that were making it confusing. The chairman. Yeah. So I was thinking I should have given us a new edition, putting in place like the layout which you propose, president, vice president, chief president, speaker of parliament, dealing with different council, take another category. It has to do with other activities. We are proposing chief
You can use a legalese. Instead of having those, you can use the legalese to reflect the position in all of those sections to refer to. Notwithstanding what is in that, so just like that.
The chairman, you have to be very careful in dealing with this. Don't forget that there are other discussions.
Yes.
And this one we have to maintain. We should be here. Especially if you don't carry the not to nationalize. You have to maintain that law.
why cannot be chief minister of this? Why cannot be general that's the case. No, we don't need it. No, it's just the proposal I'm making, not that I'm making submission. I'm still in line with what you are proposing. But I want us to be clear on the text provided to us. If you read the text, it's very clear voluntarism or honor any declaration of allegiance. That is what we are, and that is what is in line, the spirit of why we are achieving to the 6-1. So if we categorize them as we started, for the other categories, so we in line with other existing legislations, it can be fine. I don't want us to go too deep. Yeah, at the end of the day, if you're talking about to be do association for volunteering, you want to be ministers, you have to go and make an amendment in 56. You know that very well, Mr. Minister. Oh yes, I'm drawing attention. You have to make one amendment 56. So we have to accept it, we have to have a revision, and we go back for 56. Because you cannot be a member of parliament, you cannot be a member of parliament as a minister. Yeah. So we are making exceptions, we have to go for 56. We want our brothers in the diaspora to be part of us. We have to be there. We have to be careful. We give both sides of the eye.
What I mean, we have agreed in principle on all of these issues. But it is now for the draftsman to go prepare a proper rendition.
But I have clearly talking about what you told us. You told us too much in this one, like on any, and it was making too noisy for us to keep to those things in the constitution. What I'm just saying, if you are with me in principle, that let us go back and look at them, we all agree, because this is not about us. This is about our own family members who are abroad, what has happened, because as a son of our family. So what she said that we now look at the legislation, we have with other legislation, so we cannot mix them up. So that when we come, we now put them properly, it is going to the constitution. So that is it. Okay, thank you.
Yes, all those in favor say aye. Those against say nay. The ayes have it. Any rendition be done?
Clarification, Mr. Chairman.
Yes, the rendition is going to be done. But I just want again to make it clear that I mentioned the proposition. Any others who fall into some of the legislation, I listed all. So let's really be clear on that particular aspect.
So what we have agreed, when you do the rendition, make sure I see it.
Yes, again,
do rendition and bring it, let me see.
Why I'm going over this again, I mentioned the position, the president, the vice president, the speaker, the chief justice. The day I made the submission, there were some other positions. But again, the House never accepted it for some of it. But we have to bring, because I raised a point about the Inspector General of Police, the Chief of Defense Staff, and many more. So let's be clear that day I made that submission, it wasn't accepted. Of course. So we have to provide safeguards. We are talking about 24 months.
This is a position that was accepted. It was an accepted position.
And in fact, I also, the honorable leader is basically there. I raised or I highlighted the provisions that we will revisit at some point, together with the draftsmen, of course, 54, 41, and then 56 to 60, and all the rest of it. Again, I just want to be on
Mr. Clark, take note. Mr. Clark, take note of that.
Sorry, I think, Mr. Speaker, honorable members, I think for government in the submission last week, unfortunately, I left the piece of paper where we had proposed the rendition for section 76. Look through my file, it's not here. But our proposal was to add a proviso under section 76 to read as if a person, not actually, and I had worked on it, just don't have it. But we basically say a person who is a Sierra Leonean by birth, but holds the citizenship of another country. We put it in the context of the negative. It shall not shall not be qualified to run for election as member of parliament unless that person has paid local taxes to the community for 5 years preceding their candidacy for such an election, and that person has been physically resident in Sierra Leone for a period not less than 24 months. And then we provided additional language to say that such a person shall not be qualified to hold office of president, vice president, speaker of parliament, and chief justice, because these are all positions in line with the presidency. Any of these persons can act as president at any time. But for the other positions that were suggested, I think, Mr. Speaker, honorable members, I laid out with concrete examples why we would design ourselves in ways that will affect us in the future if we attempt to extend such a restriction to other positions, including Chief of Defense Staff, Inspector General of Police, noting, as I said, that we have had foreign nationals holding offices before, or that the Sierra Leone national has served as Chief Justice in another country before, or in that country, and their constitution doesn't provide for being in line to act as president. And then, of course, other examples about Governor of the Bank of Sierra Leone provided an example of the current Prime Minister of Canada, who was the Governor of the Bank of England, etc., etc. So, noting that Sierra Leoneans by birth who will hold citizenship of other countries, but might have significant contributions to make to various sectors, and at a particular time when they might be the best fit to serve in these positions. Our submission, Mr. Speaker, honorable members, is that we should not restrict ourselves too much. But for government, we are very happy keeping these restrictions to the positions that we have highlighted, which is one, such a person will not hold the office of president, vice president, speaker, and chief justice. That is the submission, Mr. Speaker.
We should also be united. We are needed for to allow all of us to serve as speaker, and there's no way we are going to make the law to deny members of parliament to become speaker. Because, for instance,
not members of parliament, who are citizens.
No, the fact that the person is qualified to be a member of parliament, they should be qualified to be part.
It's like saying a dual citizen can become the president.
It's like, why are we allowed?
Do you accept that?
They are members of parliament.
Hold on, do you accept a dual citizen becoming a president?
No, he is not a dual citizen because he is a member of parliament. We are also saying that we are also now stating that members of parliament, we should have two categories of members of parliament. We have people who are dual citizens and people who are not. And it's the next section 78 of the Constitution. It said that members to be qualified speaker.
So you are against it?
Yes. So if you are a member of parliament, you should be qualified to be elected as a speaker.
Let me understand something. So you are against dual citizens?
No, we are not. I am against the decision that members of parliament who are dual citizens should not serve as speaker. If they are qualified to be members of parliament, they should be qualified to be elected as well. They should be qualified.
The only reason why they do not want the only reason why they do not want them to become speaker is because he cannot be president. He cannot be president. And the speaker acts as president. That's the only reason. The speaker normally acts as president. The chief justice normally acts as president. As a matter of fact, I've acted as president over 7 times. You cannot have the dual citizen acting as president. Mr. Chairman.
That will be defeating of It will be defeating of
So what do you say?
If you are coming from outside parliament, you should have served parliament for 2 terms. And if you are coming from within parliament, you should have served parliament for 1 term. If we now state that as a member of parliament, you are not qualified to be elected as speaker because you have a dual citizen. How did you come to parliament? Your presence as a member of parliament qualifies you to be elected.
Hold on, let me hear.
Mr. Chairman, you know, everywhere you to be president,
yes.
Serious office.
Yeah, you have to be. It's
serious office.
The president
For
is
you
not.
to be
You don't put the
president
president for anybody.
that's what we did against. That's why just keep in mind the voluntary naturalization that you have voluntarily naturalized for carrying a dual citizenship.
Yes.
So we have to make critical decisions on behalf of the state. And we are acting as president in the 2 interests. So we don't even want to be, we have placed a bar. We are president and vice president. You can't be president. That is the omnibus provision. President and vice president. So we don't even want to act as president in that capacity. That's why we are putting Chief Justice and the Speaker of Parliament. Because you have acted, yes.
I don't think the people you are fighting for. I don't think they are fussy about that. Because the point, what I'm saying, the only reason why the Speaker, the Chief Justice, Vice President, those positions are being accepted is because you cannot be a dual citizen and become the president of the nation. It's a matter of allegiance. It's a matter of allegiance. It's a matter of allegiance. You cannot be a dual citizen and become the president of the nation. In fact, it's almost all over. It's almost all over. So if we have a unique situation in Sierra Leone where we want to bring our brothers in, then we can still bring them in with certain safeguards so that we don't compromise the security of the state. With certain safeguards. That's the only reason why.
Mr. Chairman, if we let us speak Mr. Chairman, the position of a minister of a state is a very sensitive position, a very serious position. If we have allowed persons who have dual citizens to serve in that position as ministers, to serve positions as members of parliament, leaders of government business, how can we now say we don't allow them to serve as leaders? Don't forget, ministers negotiate contracts on behalf of the state. They come into agreement on behalf of the state. So if I want to allow them to serve, it is like consequence of section 77 of the law. It is like consequence of section 77 of the law. Because they will get them to be qualified to be speaker, you should be qualified, you should be a member of parliament. How can you have a member of parliament and you not begin to draw the line between, you are just MP, to just MP, you don't qualify. If you are qualified to be a member of parliament, you should be qualified to sit in that position.
Hold on. You are not saying, you cannot it's okay. Yes. Where have you seen God voluntarily giving his inheritance to be president? Where have you seen that in the world? There's no legal contract. Nowhere in the world. Not only make ourselves funny, we are making this presentation funny. Are you saying you are American citizen or you are a citizen of Ghana, not to be a citizen of Australia? You are acting as a president. You are acting as a president. So, if there is submission, we continue to put restrictions on the seats. This is an exception. In other places, you cannot even be in America. You cannot even be a member of the police force. When you have dual citizens, you cannot even be a member of the police force. So they are bad. This is complete bad.
that you cannot be president and vice president. The reason why I bring the chief and the speaker because they are acting in that capacity. Let me be realistic. These are exceptional clauses. You have ruled. You have not an hour ago. Exceptional clauses. We are not making it 76. So they accept. Yes, you can be a member of parliament, but it's under the domain of parliament and the president.
Yes, if you want to be speaker, you go and
exactly.
relinquish your citizenship. If you want to become speaker, then you go and relinquish. You know, so about that. You go and relinquish the other let me know the chief whip.
Yes, as we got Mr. Chairman, I think I've been the minister and the
yes.
There should be a bar. You can come to parliament and have that situation. But you cannot buy to become a speaker.
The speaker, if you don't become speaker, you will not put your
as long as the council
yes. The chief whip is still in text.
As long as there is a law,
yes,
you can come to parliament, but you cannot buy to be speaker. Or even the president at that time.
Yes, you can go and relinquish.
Exactly. That's why the second thing, Mr. Speaker, when I'm going to talk about having a local tax for 5 years, as I'm talking to you now, my daughter is in America. I have local tax for her for a year. So that's it will not work. It's not work. Thank you. You can take local tax even outside the country as long as they belong to that particular country. So that makes it easy. But I do with you and the speaker. When you want to be speaker of this parliament, because I'm sure the speaker has acted as president more than twice. You cannot have
seven times. I have ruled you 7 times.
Okay. You cannot have somebody who has finished become a speaker of parliament. When you want to apply for speakership, you go and denounce your I agree with you.
So honorable Bashir Siliki, I don't think that is Mr. Chairman.
Can we clarify something, Mr. Chairman?
Hold on. You can be qualified to become speaker, but you have to, even if you are a dual citizen, before you become speaker, you have to go and relinquish. Because when you occupy that position, you act as president.
I was a member, I was a member of parliament when we amended. And Section 78 reads, Mr. Speaker, it reads that if you are coming from outside parliament, you should have served parliament for 2 terms of 10 years. So if you are coming from within parliament, you should have served parliament for 1 term of 5 years. As a member of parliament who have served parliament for 1 term, or if coming from outside who have served for 2 terms, it is better we say let us go back and amend Section 878 amended.
We cannot amend. We just say Mr. Chairman, yes. Okay, Mr. Chairman,
Mr. Speaker, honorable members, so the restriction, if you hold...
Sergeant at arms, I told you to close the door, not so? That's a simple directive. Close the door. Only members of parliament are allowed to go out and come in. Carry on.
So the restriction, just to be clear, if you are a Syrian by birth, but hold the citizenship of another country, the restriction is actually for the presidency. So, which means you are getting the right to participate in the politics of the country, but noting that you have a restriction to occupy the presidency. No, please. You have restrictions to act to occupy the presidency. If you want to occupy the position of president, then you relinquish that additional nationality. Now, the reason why these other positions are coming into play, it's simply because these persons could act as president at any time. And so it is to ensure that if someone who is a Sierra Leone back but holds the citizenship of another country gets into the political space, we ensure that that person does not act in the position of president. That is the only reason why Chief Justice and Speaker are coming in. Now, we do not need to amend Section 78 because while Section 78 lays out very clearly persons who could be elected as Speaker, the restriction in 76 will apply if that individual wants to become Speaker. That is what this will mean. So we don't need to amend 76 because there is already a restriction in 76 which will apply to President, which will apply to Vice President, which will apply to Speaker, and which will apply to Chief Justice. That is what this will mean. Thank you, Mr. Speaker.
That's for page. Please, honourable members, I would rather want the leader of government business and the chairman legislative committee or the leaders to take the lead because you debated, all of you debated. Because I don't want to open this thing to a debate.
Yes, sir, Mr. Chairman.
On this particular, what do you want to say on this matter?
No, Mr. Chairman.
We have heard this.
Mr. Chairman.
Yes. Yes.
On this particular. Yes, sir. Mr. Chairman, I had the visit of the minister. The last time, one of the safeguards was about the contribution for the social security for a period of.
Of course.
Yes, but when the new edition was pronounced, I didn't hear that.
That's what should be included.
Yeah. So it's still part of the
of course.
Okay.
Yes, Honorable Bakari. 1 minute.
I think we are gradually getting entangled in this whole issue. So I am proposing that the best way to get ourselves out of where we are now is that maybe we maintain the extant law. So how could you discriminate against someone who has been an MP maybe for 2 terms and yes, and they are moving to the position of becoming speaker?
There is no discrimination. It's not a condition. There is no discrimination. You are free to become, but you have to. Nobody debate on this matter. Nobody debate. It seems there is confusion. Hold on.
Mr. Chairman, I think we are implementing SO42.
Yes. Honorable leader. Yes, let me hear you.
Mr. Chairman, I therefore move on suspend SO52 so the business of the House will continue.
Any second. All those in favor say aye. All those in favor say aye. Aye. Those against say nay. The ayes have it. Yes, leader. On this matter.
You see, I've started seeing the bureaucratic provision. Trying to see genuinely, we want to amend 76. I mean, those in diaspora, I don't think they intend. It's really for them to come and be president. It's really to give them space to really participate in our democratic process. It gives some leverage. You know, I've not seen anywhere where you have clearly voluntarily declare yourself to be
dual citizen in another country. Everybody knows about it, and you are going to be a president.
Yes.
No, let me ask you a president.
Yes.
So you need to be careful. It's a serious business. The AG has advised us. He's a legal advisor. No matter what you say, he said these are exceptions. He brought his amendment. He said these are exceptions. It cannot be. So we have to place some seriousness in the legislation. That's just that. So I appeal to my colleagues, deputy leader, that because we are not giving in. Initially, we don't access him to seats. We have to start somewhere. And even when I reminded him about 50 seats, he said he will now amend. When you do something, you take care of it. So we are going to look at all these provisions. So cannot be examined with the extant law.
Yes, we will proceed. That's for page 14, page 15. Is it still on this point? Honorable Batu, still on this point?
I still believe we should amend section 17. I might not win, but let me just raise my position. And it should be
yes.
Section 78 was amended by all of us. This parliament, it was amended. I know, Mr. Speaker, Mr. Chairman, honorable members, when we came to this parliament in 2012, we had a lot of persons coming from the diaspora who were members of parliament. And after today, Mr. Speaker, nobody will question who has citizenship or not. All of us will have to contest elections. Then people will have to contest elections, and they will come, and nobody will have to declare. Nobody will have to declare that, oh, it has to be that 15 or hours. We are all saying
which part of section 78 do you want amended to pass?
That is the qualification of the speaker.
Mr. Speaker,
it is amended.
Read section 78.
Section 78 reads.
Read section 78.
Section 78 reads. So it is not here. You cannot amended, sir. It's amended.
Point of order. 34. The sign note has to do with the High Court. Mr. Chairman. Mr. Chairman. Our colleague needs to understand. Yeah. So no, Mr. Chairman, my colleague needs to understand. You just want to when we push. Somebody said if I help just maintain extra condition. Basically, is to have our fellow citizens abroad to participate in the electoral process. But you cannot see I'm coming to be an American, to be Australian, you want to be president, not to be Speaker of Parliament. There should be a bar.
So that when
there should be a bar.
So that you are almost in America.
If you go, you are right. You are right. Because you are not citizen. You are right. Colleagues, the minister. One minute, please. The minister has proposed for us. He has made the position very clear that let us accept the amendment and propose with an exception. Let us move forward. Our colleagues in the diaspora, I think what they propose, what I have from there, I have a text from there. That they even talk about if you have 5 years, nothing. Because all those things, they are never mentioned that you want to be president. If you want to be president, recuse yourself. Just apply that so my allegiance is gone. I'm now purely Australian. I don't have to do a anymore. That's what I say. But let the nation, beyond this function of Australia, let us see us as a serious legislator that we are putting a power on presidency.
Of course.
This position when you are in here, nobody can stop you.
Let the proper rendition be done, man. Let the proper rendition be done to that effect. That's for page 14. Page 15. Page 15.
Page 15. Yeah. Mr. Speaker, actually I'm pleading, and I'm sure our minister will agree with me. And I'm talking about where members are obliged to resign from public office at least 6 months before the date of election. Let me land, please. Let me land. No, we did not. No, am I protected?
But we passed that already. Let me hear you.
Yes. Okay. Hear me, Mr. Speaker. Mr. Speaker, we have our, government workers, like the police, like the military, like the nurses, who intend actually to come to Parliament one day. And their salaries will not allow them to be affected to resign 12 months before.
We have voted. Yes. So, page 15, page 16.
Page 16, Mr. Chairman.
Page 16, yeah.
Let's
16.
I'm still on page 15.
Yeah, what is it?
Let's just be clear here because, again, top part wherein they mentioned the Anti-Corruption Act of 2008, we already.
Yes, proceed.
Yes, the page 15, just a reminder that we took from the mid to the bottom part of it to the Public Elections Act.
Yes, Honorable Conte.
Yes, if you can recall, starting from C, the AG made that clarification. What you have in paragraph H, it was a mistake, it becomes paragraph E. So, again, Mr. AG, in page 15, just for the records. Remember, we had H, but again, you came up and said it was paragraph E.
Yes. Yes, take note of that, AG.
Yes, Mr. Speaker, Honorable Members, that is amended.
Yes, and the bottom aspect of it was moved to we agreed to move it to the Public Elections Act.
Correct.
That's for page 15 also?
Yes, 2.
Is that noted?
That's noted.
That was.
We dealt with all of these provisions.
Yes, no, Mr. It's the confirmation, we understand.
Okay, yes, take note of that.
Like you said, we're going page by page, just the confirmation.
Yes, Mr. Minister, take note of that. Now, page 16.
And page 15.
Yes.
Like, just a clarification for the AG, sir.
Yes.
We are talking about 2 plus 2. You talked about E.
we're talking about election-related offences. Somebody being debarred for 12 months, a bit convicted for 12 months, and should not participate. We can the AG, because election-related offences is not, is for me, it's so big, it's not, we don't have no qualification for that. It can be minor, it can be major, it can be. So when it's about
major, as long as you have been convicted, they should not qualify.
Mr. Chairman, like my argument here is we talk about the dropping of charges or cases against presidential candidates for political reasons or non-political reasons. So we now qualify that both civil and political. Now you now come to election-related offences, and we are all politicians. Somebody somewhere will just look at you at one point, let's say you committed XYZ because of Mr.
Let me talk to you on this. You see, when you make laws, these minute details about life, you cannot put into law. If you want to take care of everything in the law, you will never end. It's a minute thing. You see, somebody can just come, redeem me, and they take you to court and they convict you. Put up a defense. You put up a defense.
Mr. Speaker, if I may. If I may, when we put disqualifiers in laws, it's only when they are established such, let us say for criminal conduct, if someone is disqualified for criminal conduct, it's only when that is established that you are guilty. It's not when somebody points to you that you've done this. It's only when you have been convicted.
And you have to go to court and convict.
Exactly. And the point is, we have also included language to read that these are offences for which someone will serve jail time. These are not offences for which the sentences can be even substituted by fines. Again, if I may add, Mr. Speaker, honorable members, as time to be corrected, whilst I argued strongly that this provision is set in the Constitution, I think the leader of government business had moved that these provisions, these proposals, be moved to the Public Elections Act. So I think where we ended with this was the removal of two from this bill. In any case, Mr. Speaker, I also want to, and I think I need to provide clarity on this issue of elections-related offences because I think the Deputy Leader of the Opposition raised the same issue. Actually, in the Constitution right now, when we see the extant law, yes, election-related offences are there. Yes. Yeah, they're there. If you are convicted of fraud, dishonesty, or election-related offences, you will be disqualified. So basically, we're just expanding the scope, right? We're just expanding the scope, but I think this House has resolved that this expansion be moved into the Public Elections Act.
Okay. Now, yes.
I understand exactly what it means, but if you say elections, related offences. Let me cite an example. I was petitioned in 2018 election. The APC won the 2018 elections. I was waiting. Why? One of the grounds of the petition was there was a fight at the polling center and I was there. And to them, it was an election-related offense that should have taken me out of this parliament because I was there and I was a candidate. So it is too vague. It is. Because as you are saying, Mr. Speaker, that even how small the offense is. When your opponent wants to go against you, and you are a strong force, they can bring allegations that and they can win in the court. We all know the court. So I was going to be removed.
When you have your right,
I
There's nothing wrong to say no the constitution. Nothing wrong. It depends on your opinion.
If you don't have evidence, you lose.
Mr. Minister, let me hear you.
I think Mr. Speaker,
yes.
What of course in the Public Elections Act, offences are listed.
Yes.
They are not vague.
Yes.
Election-related offences are specific. If they are not outlined in law, you cannot be charged or prosecuted.
But I think this one is part of those laws.
Exactly. But also, Mr. Speaker,
you can raise that in the Elections Act.
Yeah, you can raise that, when you look at the sections that outline offences that are termed as election-related offences. But also, Mr. Speaker, I think we need to establish one thing. Again, I say, when we last discussed these proposals, my understanding was that we settled on they moving to the too detailed to move them to the Public Elections Act. If it is the position of this House that these proposals be discussed in the context of the bill, then let's discuss them. But if it's the position of this House that these should move to the Public Elections Act, then I don't think we should be discussing them now. We can wait till we get to that.
Mr. Chairman, the reason why
yes,
leader. Because he made a very salient point, which there are reasons for some of these trials not to really state in the Constitution, because we have challenges with them before conviction. The issue here is conviction. When you are convicted, you don't contest the conviction. That is clear. But the reason that I brought to you before why you should take the public elections, because I argue on behalf of rape and sexual penetration. And I said that law, as I speak, not supposed to do so. There is an administration that's supposed to do as a nation, we have not done. The administration of forensic testing. And by the time you want to ignore a charge of terrorism, it's something like that. So he says, be it in the Public Elections Act, play more role. By the time you can broaden into the nation, election violence, in fact, the election violence or election offenses, they are well attached to the Public Elections Act. Whether you are the seat or not here, those things are very, very clear. So for me, we should move them. I think the age has been on serious, but what should maintain, and that's what in the Constitution, when you are convicted, now we are not saying because we have to deal with such offenses, that is the new ones coming, he has stated, the rape and sexual penetration, let me treated in the Public Elections Act. So we can exhaust it extensively before taking decision. That's our offenses, and in fact things that are bad not to contest. So the most serious that be accepted. So that's what we are saying. So addendum to that, we can again review for every election the dynamics. We can review the election offenses and we brought it up to see what are the election offenses coming up as we know. Let's go like the acts and other special amendment Public Elections Act.
Page 16. Are we okay with page 16?
16.
Page 16. Yes, Honorable Mustafa.
Still, 16 there's a follow-up from 15. 3. In its qualification under subsection 2 shall end. A. 5 years after the sentence has been completed or the person is barred.
We deleted all of those. We deleted all of those. In fact, all of page 16 and page 17.
Why not 10?
Yeah. Okay, we maintain clause 17. Downwards. We only maintain. In fact, let's just debate on 17 and 18.
Clause 17.
No,
Speaker, before that.
Yeah. Yes, Mr. Minister.
Yes, so if I may, with your leave, Mr. Speaker, still on criminal conduct. First, let's note that certain criminal conducts are listed in the Constitution, which will disqualify someone from serving as a member of Parliament. 76(1) D says if he has been convicted and sentenced for an offense which involves fraud or dishonesty. And then E, which we have proposed to delete now, says if he is under a sentence of death imposed on him any court, because we have I'm just reading for the Constitution.
Oh, okay.
Because we've abolished the death penalty. And then section 76 of the Constitution, subsection 2, says a person shall not be qualified for election to Parliament if he is convicted by any court of any offence connected with the election of members of Parliament. Mr. Speaker, I just want to add that we note the specificity on D, fraud or dishonesty. So now we can say corruption-related offences. But I just really want to go back to cabinet. The seriousness that cabinet attaches to persons who have been convicted for offences like treason, murder, manslaughter, rape or sexual penetration were particularly important to His Excellency and the rest of the members of cabinet. So my question would be that yes, there are broader offences, especially relating to, say, the provision saying if someone has committed an offence for which they've served a sentence of 12 months, minimum 12 months, they will be disqualified. Is it possible to say yes, the proposal on 12-month sentence does not come into Constitution, but because the Constitution, the extant law is specific on fraud and dishonesty, and the seriousness that we attach to rape and sexual penetration, murder or manslaughter and treason, is it possible to keep these three categories of offences within the Constitution? Not two categories.
Yes, I think still try to draw attention to 76. Now, if you look at 76, it's really limited in terms of offences. We don't have to carry. I'm crossing before.
Yes.
76, Mr. Chairman. Let me read so that we can. First, we can talk about I've accepted the proposal for conviction. But how do we deal with cases of potential penetration? How do you dishonest? Let me dishonest. Let me read 76 D. Let's start with D. We said if he has been convicted and sentenced for an offence which involves fraud or dishonesty. So for us, we can hold this one as an extra law, but in the public elections, we now this what are the things that support dishonesty? And fraud. What do we consider fraud and dishonesty? We put it in the public elections as clear as in fact, that is one. And under offenses, what you have stated again, we can roll it up. Other issues that related to sexual penetration, even terrorism. The one that we need to remove is the death penalty. We don't need it anymore. Now, because they said we have amended death penalty. So we can really now give this conviction. Because it said if he is under a sentence of death, the normal person specifically. So we want to be consistent with what you have done. We are repeating the death penalty from the Constitution. Imposed on him or by any court. So we need not to have this one. The chairman, are you with me? The death penalty should not start.
The only thing is that I think you are all missing the point. This is something we deleted.
No, he brought in fraud.
It's already in the public elections that is in the Constitution. I don't know why
he is making reference to this but fraud is both fraud.
What is it of this one? Yeah, of course.
The E is gone.
Yes, everything is gone.
No, D is not gone. What he is saying, he wants us to maintain this as a
that one is already in the Constitution.
Yes. So what when we come to public elections, we itemize them.
Okay, when we come to that. Let's not discuss this. We are taking this to the public election service. Maybe to labor the point of this. We should only deal with clause 17 and 18. Yes, 17 and 18.
Mr. Chairman, even 17 and 18, we had a debate on that. I don't think we had an issue
Yes.
about the issue of proportionality of the police and military, and we are very clear about the rules of conduct. Of course. So, again, what I think here in 17, 18, the clause I was looking out for, the provision that we can start under the Electoral Commission is here, act in a partisan manner. I think we put it here for the police and military. Yes. So we can get that in order to Chief Electoral Commissioner act in a partisan manner.
Okay.
Thank you very much.
Mr. Chairman, I want you to give you feedback. Mr.
Speaker, I've confirmed with the General Government Business and those proposals we are expunged and move to Public Elections Act. We can take at the stage that we are. Thank you.
Yes, thank you. So we are done. Mr. Minister, can you now move? Mr. Minister.
Mr. Speaker, Mr. Chairman, honorable members, I move that Part 1, clauses 1 to 18 stand part of the bill as amended.
Honorable members, the question is that parts 1, clauses 1 to 18 stand part of the bill as amended. All those in favor say aye. Aye. Those against say nay. The ayes are
Part 1, clauses 1 to 18 form part of the bill as amended. The House resumes.
Yes, Mr. Minister, report.
Mr. Speaker,
Hold on. You know government business. Let's go. Let me do Honorable Mara, please, Mara, please go. Honorable Mohamed Bangura, please come. Honorable Mohamed Bangura,
idea towards the constitutional amendment, the 50% or 50+1 is that the 50+1, we at the last election with the PR system, we personally are support. The reason be that we all know that this country that they do election, we don't see they get amendments. So we don't get runoff, or we cancel or die, or me or die. How can I call it? Honorable die. We don't do that runoff election. A lot of problem. Other things they do. So see, so me, I talk to all the companies for me to accept that PR system, because now the political party then they appoint policy 1, 2, 3 policy. After this policy and this policy, I have this policy. For example, I don't know, give an example to the councillor who don't tell me time. The insurance CP councillor OG, where he died, no election. They just appoint one with the second. But they say now, we can do election that thing all two. So me, Professor Benga, I support the PR system, and the 50+1%, I support that very well.
According to the citizens of this country, we dey try our best for let government system try for improvement in this country. The 50% or the 50.1% wey dey count, and so now they fine for let you become a president, because traditional 55% wey dey defend pass no more go per runoff. So now we say we no go one runoff, we want 110 go, because that runoff then a waste of resources in this country. So we money dey go. Besides that, this PR system wey dey count in the country, me I look at and say I no get problem with that day, because every constituency wey you say na this policy you allow make as a constituency, let policy to map na ya, the people that dey work go meet too much. But now the PR system, it depend on now. It easy for everybody. It depend on wetin you can do for the people there. If you get power, you make that, then it's okay. Because government business, government ain't get everything.
Maybe this PR system, I not say na better thing for we Sierra-Leoneans, because we be very used to that. Where they go vote, that we go honorable, we go councillor them. If you some type in a way, we able to go to the honorable or councillor, go council them, they help we. But right now, this PR system, hey, some type in a way, where are they going to go? They say na the streets. You say go wool, but they honorable and they councillor them, they be fine. Na be fine system. One government left that system, because anything the honorable be responsible, you councillor be responsible. Well, now they say, then people they say, no, now party and put you inside. Yeah, we not can work for party. No, so that system is not good for we Sierra-Leoneans.
I mean, say 49 person get like 49. The one get 50% plus one person. Like if them for go make other election, you better let them do the election, because let them waste other resources. For let them make other election, let run off no go there. Because Wilbur first now, I'm not able to sabi the honorable way there. Because of the PR. I'm not sabi, because we na other side, we na one great honorable, they represent we all. We may not sabi self. We don't have the honorable in the district. Like me, I go let them culture, because if we get issues them, like anything where I'm about now bridge or everything, and then we will sabi the person when the honorable, we will go meet them for our own problem.
No idea towards the constitutional amendment, the 50% or 50+1 is that the 50+1, we at the last election with the PR system, we personally are support. The reason be that we all know that this country that they do election, we don't see they get amendments. So we don't get runoff, or we cancel or die, or me or die. How can I call it? Honorable die. We don't do that runoff election. A lot of problem, other things they do. So see, so me, I talk to all the companies for me to accept that PR system, because now the political party then they appoint policy 1, 2, 3 policy. After this policy and this policy, I have this policy. For example, I don't know, give an example to the councillor who don't tell me time. The insurance CP councillor OG, where he died, no election. They just appoint one with the second. But they say now, we can do election that thing all two. So me, Professor Benga, I support the PR system, and the 50+1%, I support that very well.
According to the citizens of this country, we dey try our best for let government system try for improvement in this country.
nation. The law na salon dey talk say for make you be president na this country, forget 55% of the vote, otherwise we dey go for runoff. The government of salon dey propose say make we change the law dey, and they propose say for make person win the first round, e forget simple majority and at least 20% na third majority of the districts in na salon. Wetin this mean? E mean say the person for get the highest vote and also get at least 20% na 11 districts of the 16 districts go get na salon, because they argue say for make you be president, you for go all about na the country for get the mandate of the people. But we na Ilraj, we think say this na issue na with democracy, we na government of the people, by the people and for the people. We believe say if we lower the bar, we go create weak mandates for the president, because it go appear say majority of the people we no want am, no vote for him, and then the go come like can be president, we be say now few people vote for him. It also appear to we say some district in Asalo them very small, other one them very big. So party we get base na boku small districts will end up win the election against the majority of this. It appear to we say the votes will be unequal. We go above the principle of democracy. We say one man, one vote. Now for pay attention and get involved. Of the tomorrow, bye. This message they come out from Ilraj.
Nation. Me and Obla make video, but this one here, Asela and Mekam, because we country to go through a very important and serious stage. We involve changing key provisions now in 1991 Constitution. And the 1991 Constitution, not to just any document, not to just any law, now the highest and most important law of the country. Now the law where they arrange how for control power, now the law where they arrange how we leaders them for exercise that power, and now the law where they arrange how governments of the day for be accountable to citizens we vote them in. Right now, Parliament they try for change key provisions them na this constitution, where therefore rearrange all entinea where I don't mention. And that therefore affect citizens than life. It therefore affect citizens than life because then changes then they therefore change how we run we elections in our country, how political parties they control parliament, and how and to what extent the government could be answerable to the people of Sierra Leone. So this not to cause for celebration, and not to rename say we can do constitutional review. We roll as citizens now for examine the provisions that we want change and ask ourselves two questions. One, then change is here, then they improve or damage with democracy. Then change is here, then therefore make the people them get a say in the democracy, or it therefore empower only political parties. Now we they encourage ordinary citizens to be part of the process, and for no say they entitled for take part in the process. Una can get involved by holding discussions amongst ourselves now in our communities, contacting our parliamentarians, asking questions, and making our position known to them. Una can even write position papers and send them to the clerk of parliament. We na Ilraj, because we believe say democracy they begin and end with the people, we don't take it upon ourselves, follow we make short videos them on them key provisions, where we go explain them in a simple, clear manner for let every Sierra Leonean within and outside Sierra Leone be part of the process. Dear, I want to pay attention and want to be involved. This message they come from Ilraj.
I don't listen to you and I don't see plenty time. Is it that you
pick and choose which one stands with waiting on a position, and the other one, the way other institution and the raise, we not stand with on a position, is not valid in this conversation.
No, so everything other person not say, we take them as part of the process. For example, if you listen to debate in Parliament when it comes to 38, yeah, the APC accepts, say, the APC members of Parliament, and I'm sure that's the position of their party, that 38 and 38A is part of the Constitution. Well and good. So my submission that for now when all these things the AG presents about PR and non-PR, I say let us delete everything that the AG brought to Parliament. Now we take 38A and we number section 38 accordingly. 38A becomes 38.4. And in some paragraphs them, so at any time when any of the situation arise for either of the system of elections to be used, it can be used from the Constitution. They say no. So it's a point like whatever we say no to is no. So let me also address the issue of new districts. President Nkrumah created 2 new districts. Not only created 2 new districts, he changed the political landscape of Sierra Leone. He creates Northwest region and he creates a Northern region. Nobody in the SLP will not say enough for political advantage. Because we believe in Sierra Leone.
No, then there was you and cry.
No, there was you and cry, but the point is,
it was condemned for doing that.
Yes,
it was part of the conversation that because of politics, because they want to get more seat na the north and northwest. That was why he was doing it.
So what happened in the end? In the end, after the creation of the northwest and the north, yeah, as a region, and the creation of 2 new districts, Falaba and Karine, the election came out. SLPP has 2 seats in Falaba. APC has 2 seats in Falaba, even though it was difficult in Karine, but he returned a president when SLPP elected president. So for me, the issue about creating new districts now in the fraction in 50+1, I am saying this here again on national radio and national television. The APC get for believe in imposition. We as SLPP and the members of Parliament, we are ready to remove the threshold of 25 or 20%, and we are ready to stick to 50+1 as recommended by the white paper of the APC-led government, as proposed by the APC in the Constitutional Review Committee, and let's move forward. Yeah.
So on the back off on that?
It is constitution. It's a bill before Parliament. A bill before Parliament is a text.
But what's not agree on the PR or first past the post?
Even the PR, they have also said that 38A is part of the Constitution. We are saying let's give number 38. Let's bring 38A as 38.4.
No, but what's in this they propose that you remove first past the post totally from the Constitution?
No, so we are not saying that now. We are saying for them we all might be comfortable. If it's the people's choice, let us allow first past the post to be as 38.2 and 38A when we amend in 2001, let it come now as 38.4 and we remember section 38.
So you still get all to the voting system
in the Constitution, and they said no.
Doc, you've been in this for a very long time, from the tripartite, the agreement for national unity. You don't sit on at the different meetings them. And recently the AG was here and mentioned that you have been one of the members of the APC saying that the technical committee we've been getting engagement with. And some of the points he made was that we don't get agreement on most of some of the issues there are about PR, about the threshold for the election of the presidency and all. What's in change? Is it the document or the agreement change when you reach in Parliament?
Well, I should say if you watch the AG on Liberty TV, it contradicts itself, because on Liberty TV he go further for say we not be don't agree on anything. We've been the discuss, yeah, but there's nothing like a definitive agreement. There were certain areas where be non-contentious. For example, the issue about the entrenched clauses, the need for their removal. That was not contentious. We agreed. And you see, I want to make people understand. So there was a spirit behind the engagements. And the spirit was that how do we work out a constitutional arrangement? We're going to stand the test of time. And we're going to reflect the current realities. And that will be informed the discussions. However, we discovered, say, whilst we were engaging in good faith, the SLPP been get other plans. For example, whilst we when the tripartite negotiations, we will think about how we can get a system we go prevent too many runoffs, we go prevent too much violence in elections, etc., etc. The issue of the threshold. Just when we come out from the tripartite committee discussions, now we get a proclamation from presidency to create new districts. And the moment they decide for create new districts, it does change the game plan. You know, and I think that's not bad enough. When they come now and go back with a bill in the parliament, the bill go totally against the spirit of the tripartite committee recommendations. You know, and so they begin suspect.
So there's issue of trust.
Exactly. With this, there's a real.
But the technical committee engagement will get now very recently, right?
Yes.
Now recent, not so after the agreement for national unity.
It was never conclusive. It was never conclusive, and even when we go for the retreat, we agree say it is not conclusive. But the parliamentarians go debate and further.
But were there things on agree on as with that time they want to spend the meetings they want to get? Were there things on say okay, this way they giving on us giving on this way? There are things on agree on.
We be agree, for example, for remove the entrenched clauses. Okay, that one it was non-contentious. We discuss to a great extent the issue of the threshold. And we put forward some proposals. We believe for get a full meeting for low able reach conclusions. But the expectation was that when the Attorney General go in a parliament, it before go reflect the spirit of we discussions in presentation at parliament. But sadly, in presentation at parliament, you not do that.
What's in on been for
example, when we been discuss PR, even though we been get the reservations about the PR, and then even at the level of the retreat, we agree say make it go back to the parliamentarians for discuss. We been proposed options for discussion. We been proposed mixed PR system, clarity on the PR system, and no. And you would recall that in many democracies in the world, they get different forms of electoral systems that they adopt. So we say, let's have a discussion around that. So the expectation was that in the AG in presentation, enough for continue with a vague to just say PR.
Okay.
Without defining the type of PR.
But don't you say now after the amendment, then now the electoral?
No.
Everybody wants some clearly defined.
You see, so what did they do? Question, give a be clear. Especially we get serious trust deficits, and if you do so with all of these things, with under PR and then the district provisions where they put inside, they say we forget 20% in 2/3 of the districts. That it automatically means say APC forget 20% in 11 districts.
Let's just say that 19 at the document. It say the repeal and replacement of paragraph E of that subsection with the following paragraph. A person shall not be declared elected as president of Sierra Leone unless at the presidential election he obtains 1. a simple majority of the total valid votes cast throughout Sierra Leone, and 2. a minimum 20% of the total valid votes cast in at least 2/3 of the districts of Sierra Leone.
Exactly. So if you get the 16 districts and you forget 2/3, it means there are 11 districts. So if we get 7 districts in the north and the northwest, and then 2 in Freetown, that's now 9. So you need for go at the southeast and get 2. But that was not the problem. The problem is that in the proclamation where this government don't make, they intend for create 2 new districts. And nothing stops the president from creating 2 new districts. And if he creates 2 new districts, where he do within him powers for do, if this bill here pass as he did, then they forget 2/3 from when I still there in the draft, we need 14 districts in the country. So which means APC need for go get 5 districts at the southeast, we say they get 20% plus. That is almost impossible when you look at the reality of how voting patterns don't be over the years. So clearly, as a party, would they see say they set trap for we? You know, when we don't get one discussion, for example, during the tripartite committee discussions, after so many considerations, the agreement then was that we go for 50+1 and then 25% in half of the districts, for just allow for inclusivity, for remove tension from elections, etc., etc. Sadly, the Attorney General will be a member of the tripartite committee. When he come now in this bill, he go against the letter and spirit of the tripartite committee recommendation. So instead of sticking to the 50+1, he changed to a simple majority, and that is totally different. And it, as if that's not bad enough, they also flag this proclamation for create additional districts, where just to explain, okay, it will make it impossible for APC, very difficult for APC for winning the first battle.
I want to seize this opportunity for extend the profound thanks and appreciation to honorable members of parliament of the opposition. I was fully persuaded and convinced, say, una they stand for the people there, and they stand for what's right. In democracy, challenges they can do. Sometimes they not easy, but come out and stand out. This now one of the finest opportunity we members of parliament and collaboratively don't decide for come out and stand out for the sake of the people of this country. Yes, we read the comments them where we get out, and we as members of parliament not for be part of a procedure we not constitutional. This now the greatest document now this nation after the spiritual books, now the greatest document in this nation we now the constitution. Any amendment of the constitution we are not able to get the 2/3 majority and not feel say we for be a party to that. So this time we take, I want to thank all the members of parliament. The public may doubt, but me, I was fully persuaded that we are together, we are in unity, we are stronger together, and our voices have spoken today a very strong message to the nation, say no force can divide us. So to honor the members of parliament, I want to honor plenty. Yes. When, because today now in parliament they go recess. When parliament reopens in October, we expect say una only come in una full forces. We not take no boycott action against parliament. Let una know that day. Already we do now that we exclude recess from on procedural amendment of the constitution. So once more, I want to una thank you and may God bless Salome. May God bless you.
To the tripartite proposal, we have 50+1 plus half of the voting district. We say fine, let's go back to that. We go look. I have had meetings with the APC team, with Mayor Akisora, Dr. Kelfalamara, Dr. Richard Conte, Ambassador Yansane, JFK. We all don't discuss, and everybody, and of course the members of parliament, everybody see we stick with 50+1. So while we will come out on the eve of the debate in the parliament, the same people will don't come and say let's stick with the tripartite proposal because that was our proposal to the tripartite committee. The same people will come out and say no, we never want 50+1, now 55% to 1. That is not leadership. That is not
You're
leadership.
surprised at the change? It seems like
I want to say I am disappointed.
In the APC people?
Yes, I want to say so. You understand? And look, I have worked with them a good deal. I have worked with them in good faith. They themselves don't talk publicly about how the office always on the open for engage. But if they get them kind of engagement, yes, then una said they come, una recommend the engagement publicly. Una recommend them to the public. Una recommend them to international actors. Una recommend them among una own party members. See, this is the progress we have made. Then at the last minute, una turn behind people them and then try to take a different position. Then give.
I only wish there should be this conversation about how we get an hybrid system where things could work. But you think this is gonna pass? It's gonna be a PR system?
Only how you PAMA is a PR system. Okay, so me I like for say as I see I'm SLPP, something they are not for divulging the public, but let me say it this way. The constitution clear. So anyhow we look at an 2028 election is gonna be PR.
How? If they not amend the constitution?
If they not amend the constitution itself, by provision of law, there is no way would they even able to go into any other election rather than PR.
Why?
38A say, if for any reason we're not able to delineate constituencies, President may direct that elections be conducted using PR. So PR is already in the constitution.
And first past the post is there already.
It's there already.
But we have a census. And Dr. Biden, I read something, just a reference that. Say, unless this government wants to say, okay, we'll let it get census again, after the census we delineate consistencies, then we not get PR.
No, the census act clear. You delineate constituencies 2 years to elections. Anything short, you can't.
So we can still get the census and not get constituencies?
Definite.
So that is the ball game of the SLPP?
That's no ball game, that's the situation. So this is why APC for just allow the PR. Because if you don't allow it, 38A will still set in.
So that's the regular
Not only there, you know, still they get the point where they make. Not what we making. Now the situation we're making. We for do census. Census now they take place. Now anybody say that now census will take place? Because of the situation we found ourselves, that now census they take place.
But census is 2 years to election. It's if it happen this
it will happen this December. Exactly. Now they conclude. Wait, yeah. We'll go for write the report.
Yeah.
And the report probably going to come out somewhere next year around. So the earliest say people work set for pull that report. Now in 3 months time, say March. If report come on next year March, from March next year to say October 2028. It's about 1 year or months.
So this is the point. Census was going to happen last year. So it was postponed to this year.
So the preparedness was a problem. Money was a problem. APC, the issues where the raise was a problem. All of these things. So census is happening.
Is this the SLPP idea of?
That's not what anybody making. It's not my making. It's not your making. It's just that census get to happen anyway.
But if the law says census will happen 2 years before the election, and
not the census will happen, then
you have the census
2 years before elections.
But that is it. But because if it happen now, we can't delineate like how you explain.
So that is why they say APC. You know, let me tell you something. Where they happen, Lamana. This country now we all get answer.
What do you think about the debates? You know, especially on the amendment bill, where don't get everybody's attention on Parliament now. What do you think about the debates so far, since you don't follow?
I think the gerrymandering and the filibustering don't make the debates on the lost team, and that's owing to several facts. One, the time management factor. We see members of parliament, some not go parliament quick, the debate not start quick, and even when the debate starts quick, at the first instance, the speaker not give time to debaters. You see a man talk for over an hour. So that's poor management of the time in that debate. But also, we see the frequent standing down of the House. You stand down for 30 minutes, it will take 3 hours. I think the by and large of it is the fact that both political parties not lobby themselves well, and the mistrust is quite huge. And the issue at stake, for me, this where I reflect and contemplate, is not a constitutional amendment bill. It's an electoral amendment bill, because it's about, Lamana, this is, for your audience, for me, reading through, watching the script, as usual, it's about who they win the presidency versus who they win the number in parliament. So this hinge on the two facts that the 50+1 and the PR system. With the PR system, it might be a case that APC might win the presidency but not get majority in parliament, as we see in the fourth parliament, of course. It can be another way around that SLPP might win the presidency and not get majority in parliament. So it's basically about the next election and not, for me, the general interest of sanitizing gray areas in the constitution. There are a lot of gray areas in the constitution.
So for you, the substance of the debates and the issues, them, the provisions, them, has it been about the people and how do we change our electoral system and reviewing with 1991 constitution, or is it about the political parties and positions?
It's about political survival, not necessarily the people. Let me just start with the latter. Not necessarily the people. Remember, the speaker asked for position papers. Usa, you see, during the debate, there was any report or deliberation on those position papers. It was my expectation that there should have been a report on the position papers received, the positions expressed, and what members of parliament think about them, putting it to a vote. All those in favor of position, I mean, you should do a collation, corroborate all the different positions and categorize them. Then you put the question to MPs. That would have sufficed in saying, oh, this is a representation of the people. But the boku over 25 to 30 position papers, which one you see them talk about? Pastor Modi wonder. In fact, what they are doing now, they have politicized the issue. All man they talk about the positions then we fit for their own argument. They will tell you that, oh, even interreligious council is against this, or even the chiefs have rejected this. That is just it.
But you're not inclusive in the document.
You're not inclusive in the document. And there is no special deliberation or procedural debate or a procedural action on the position papers. So for me, it's about the political party and survival. How? See, waiting and get a unanimous agreement on. They are unanimous. The most unanimous agreement is the fact that they say you never get independent presidential candidates. What is that saying? APC and SLPP want for continue for perpetuate the hegemony, meaning that it will just be green or red, nothing more than that. Because we've seen the history.
They're scared if somebody there is a fallout
and if you look at the political trend across the globe, there's what is called a rising trend in populism. So maybe the next forces say Tango can country will get one popular individual we might surpass these political parties and go on for introduce radical reforms. So what they've done, they've shut the door that no independence presidential candidate.
And
they agree on that. So it's about their own political survival and political interest, not necessarily the people. If this was about the people, why, for example, they not amend the provision in the constitution where say certain rights should be justiciable? Things like water, good road, good health.
No, then they say they cannot the bigger, the broader constitutional review.
So when would that be?
Well, the age say maybe before we go get a referendum in 2028 or before 2028.
It's impossible. Is struggling for with census. Do you know what referendum is like? A semi-elections. It involves huge resources. So I mean, they just want to call people at in my estimation that okay, be hopeful, be expectant, not just pass this because they know there is already a gridlock with this one. So they want to just use this like we can say. Call people out with pepper water. So okay, well, if which one are expected not there, the next one it will capture them. So for me, it's about the political parties that survive.
Every great day begins the night before. After a long day, home is where comfort begins. With trusted Vitafoam mattresses, fresh bed sheets, Salon Titty mattress protectors, and bamboo memory pillows, every night becomes a peaceful night's sleep. Sharing a warm drink with Salon Titty honey. Simple family moments. Because these little moments make a house feel like home. A comfortable home brings peace of mind, and peace of mind brings sweet dreams. A good night's sleep gives us the confidence to do our best, whether it's school, in hospitals, in workshops, or welcoming guests in hotels. Vitafoam Brookfields is proud to be part of your journey. From Vitafoam mattresses, pillows and bedsheets, to Salon Titty mattress protectors, bamboo memory pillows, honey and tissue. We bring comfort, quality and trusted service Vitafoam Brookfields has proudly served families, hotels, carpenters and businesses across Sierra Leone. Visit us at 29 B. King Harmon Road, Brookfields, Freetown. Call +2 32 762 71771 or +2 32 992 71771. Follow Vitafoam Brookfields on Facebook. Email vobrookfields@gmail.com. Visit vitafoambrookfields.com. Vita Brookfields, home of Salon Titi.
Notification pops up. You think you've received money. Seconds later, your phone rings.
I sent the money by mistake. Please send it back immediately.
Don't rush. This is a common scam designed to pressure you into acting before you verify the transaction. Before sending any money, always confirm that the money has actually been credited to your Orange Money account with Orange Money contact card as the sender's name, not just an ordinary phone number. Check your balance, verify the transaction, and never rely on a notification or a phone call alone. If something doesn't feel right, stop and contact Orange Customer Care on 111 or 505 to report fraud alert.
Orange.
Cribs International is a one-stop shop multimedia and entertainment company based in Sierra Leone with full capacity to stage, produce, manage entertainment, content, and projects across the Manu River Union. For all your virtual events.
Hey, you think you got what it takes to be Sierra Leone next top DJ?
Whether you're a professional DJ, radio DJ, upcoming DJ, club DJ, streets DJ, even pop DJ, or DJ self-made DJ and bedroom.
This is a chance for stepping to the spotlight, compete for being the best and choose a long team off.
Bring you energy, bring you originality, and most of all, bring you A game, because this might be your moment.
If you believe say you get wetin it takes for win the 200 million, get his form today. You ready? You ready?
Vibes and Spin DJ's battle coming soon. Brought to you by Cribs International.
You just don't come. Yes, I say you just don't come for Save and Win Big. A call to business savings and loans, where they can call ACTB Bank. Doubling plan the ACTB Save and Win Babala promotion, where they start from July 13, 2026, so to January 31st next year, 2027.
All you get for do, now for just save 10,000 euros every month and qualify for the monthly raffle draw. That's how you get the chance for refined pricing like microwave, DSTV set, mobile phone, freezer, plasma television, gas cooker, and plenty other things.
And not tap though. If you grow your savings to 60,000 by December 31st this year, you will qualify for take part inside the grand draw. Usai, you will start the chance for drive away with the grand prize, with a one brand new CS55 Plus Jeep. Well, no one day drive it. Yes, you hear me. One brand new CS55 Plus Jeep.
For make you never miss this chance for winning all the big prize and yaso, now for us go open account 110 if you never open a 8. If you already get account with ACTB Bank, then you already get advantage. Just continue for save at least 10,000 euros every month and qualify for the monthly draw then and the grand draw.
For more information for this promotion, now for call the ACTB Contact Center on 9595 on any AfriCell or QCell number.
Ah, exactly. Yeah, Central Boy. We did at the house like Toa, Bilam from scratch like Noah. Even though I don't know her, Fala Oda Sabi Hood make you baby fast in the end me like a Toa. Above the game, just observing all the drama. Rappers look up to me like I'm Victor Weminyama. I get big ego and I not believe in karma. Only thing where to go around and come around like this 17-inch Yokohama. I did up like Leicester. The last one, just the first semester. They already know I got something big coming to the face in the third trimester. I switch the flow like a sound selector. Good girl want on the pressure. The Y'all say like man we get power, so I charge on the wall like Tesla. If they don't know what you do, a man them must suppose. Not even do a man you do, a man them must suppose. But if you see how I can bust the shows, then you go say need no day for juxtapose. But watch you baba, me not kingdom me city and the city where you come up. Then now able retire me, so now then the feds for space are the list of the one that will inspire me. Mirror on the wall, who that bad pass? I ain't really short, but it weak like back pass. Who that laugh first, who that laugh last? Who that hop on the beat left empty, cacas. Call me name if you want some more. Show up and make it rain and pour. This summer I'm back on tour. I'm live in London, September 4. 1, 2, 3, 4.
Here is a public notice on the 2027 Holy Pilgrimage registration payment from the Sierra Leone Commercial Bank. The Sierra Leone Commercial Bank Limited hereby informs the general public that payments for the 2027 Pilgrimage to Mecca registration is at a cost of 7,000 United States dollars or its equivalent in leones can be made into the following designated accounts. US dollar account name, National Pilgrimage Account, Sierra Leone Commercial Bank. Account number is 003001 039 708 412 187. Swift code is SLCB SLFR. Leone's account name, National Pilgrimage Account, Sierra Leone Commercial Bank. Account number is 003 001 039 708 112 166. Prospective pilgrims are kindly advised to make their registration payment at any SLCB branch nationwide on or before 16th November 2026. Sierra Leone Commercial Bank Limited remains committed to providing convenient, secure, and reliable banking services in support to this important spiritual journey.
Every great day begins the night before. After a long day, home is where comfort begins. With trusted Vita foam mattresses, fresh bed sheets, Salon Titty mattress protectors, and bamboo memory pillows, every night becomes a peaceful night's sleep. Sharing a warm drink with Salon Titty honey. Simple family moments. Because these little moments make a house feel like home. A comfortable home brings peace of mind, and peace of mind brings sweet dreams. A good night's sleep gives us the confidence to do our best, whether it's school, in hospitals, in workshops, or welcoming guests in hotels. Vitafoam Brookfields is proud to be part of your journey. From Vitafoam mattresses, pillows and bedsheets, to Salon TT mattress protectors, bamboo memory pillows, honey and tissue. We bring comfort, quality and trusted service. Vitafoam Brookfields has proudly served families, hotels, carpenters and businesses across Sierra Leone. Visit us at 29 B. King Harmon Road, Brookfields, Freetown. Call +2 32 7 227 18771 or +2 32 992 71771. Follow Vitafoam Brookfields on Facebook. Email vbrookfields@gmail.com. Visit vitafoambrookfields.com. Vita Brookfields, home of Salon Titi.
Notification pops up. You think you've received money. Seconds later, your phone rings.
I sent the money by mistake. Please send it back immediately.
Don't rush. This is a common scam designed to pressure you into acting before you verify the transaction. Before sending any money, always confirm that the money has actually been credited to your Orange Money account with Orange Money contact card as the sender's name, not just an ordinary phone number. Check your balance, verify the transaction, and never rely on a notification or a phone call alone. If something doesn't feel right, stop and contact Orange Customer Care on 111 or 505 to report fraud alert.
Orange.
Nation, the Leone salon dey talk say for make you be president na this country, you for get 55% of the vote, otherwise we dey go for runoff. The government of salon dey propose say make we change the law dey, and dey propose say for make person win the first round, e for get simple majority and at least 20% na two-third majority of the districts in na salon. Wetin this mean? E mean say the person for get the highest vote and also get at least 20% na 11 districts of the 16 districts dem go get na salon, because dem dey argue say for make you be president, you for go all about na the country for get the mandate of the people. But we na Ilraj, we think say this na issue na with democracy, wey na government of the people, by the people and for the people. We believe say if we lower the bar, we go create weak mandates for the president, because it go appear say majority of the people we no want am, no vote for am, and then the go come like can be president, we be say now few people vote for am. It also appear to we say some district in Asalo them very small, other one them very big. So party we get base na boku small districts them will end up win the election against the majority of this. It appear to we say the votes will be unequal, we go above the principle of democracy. We say one man, one vote. So now for pay attention and get involved. Dr. Tumara Bambai. This message they come out from Ilraj.
Nation, me I no blame make video, but this one here Asela I make am because we country to go through a very important and serious stage. We involve changing key provisions now in 1991 Constitution. And the 1991 Constitution, not to just any document, not to just any law, now the highest and most important law of the country. Now the law where they arrange how for control power. Now the law where they arrange how we leaders them for exercise that power. And now the law where they arrange how governments of the day for be accountable to citizens we vote them in. Right now, Parliament they try for change key provisions them na this constitution, where therefore rearrange all them thing here where I don't mention. And that therefore affect citizens than life. It therefore affect citizens than life because then changes them they therefore change how we run we elections in our country, how political parties they control parliament, and how and to what extent the government could be answerable to the people of Sierra Leone. So this not to cause for celebration and not to rename say we can do constitutional review. We roll as citizens now for examine the provisions that we want change and ask ourselves two questions. One, then changes here, then they improve or damage with democracy. Then changes here, then therefore make the people them get a say in the democracy, or it therefore empower only political parties. Now it make we they encourage ordinary citizens to be part of the process and for no say they entitled for take part in the process. Una can get involved by holding discussions amongst ourselves and our communities, contacting our parliamentarians, asking questions and making our position known to them. Una can even write position papers and send them to the clerk of parliament. We na Ilraj, because we believe say democracy will begin and end with the people, we don't take it upon ourselves, follow we make short videos them on them key provisions, yeah, where we will explain them in a simple, clear manner but let every Sierra Leonean within and outside Sierra Leone be part of the process. Dear, I want Leone pay attention and Leone be involved. This message they come from Iraj.
You know, I don't listen to you, and I don't see now plenty time. You know, is it that you they pick and choose which one stands with waiting on a position, and the other one, the way other institution and they raise, we're not standing with on a position, is not valid in this conversation.
No, so everything other person won't say, we take them as part of the process. For example, if you listen to debate in Parliament when it comes to 38, yeah. The APC accepts, the APC members of Parliament, and I'm sure that's the position of their party, that 38 and 38A is part of the Constitution. Well and good. So, my submission that for now, when all these theory the AG presents about PR and non-PR, I say let us delete everything that the AG brought to Parliament. Now we take 38A and we number section 38 accordingly. 38A becomes 38.4. And in some paragraphs them, so at any time when any of the situation arise for either of the system of elections to be used, it can be used from the Constitution. They say no. So it's a point like whatever we say no to is no. So let me also address the issue of new districts. President Nkrumah created 2 new districts. Not only created 2 new districts, he changed the political landscape of Sierra Leone. He creates Northwest region and he create a northern region. Nobody in the SLP will not see enough for political advantage because we believe in Sierra Leone.
No, then there was you and cry.
But the point is,
he was condemned for doing that.
Yes,
it was part of the conversation that because of politics, because one get more seat na the north and northwest. That was why he was doing it.
So what happened in the end? In the end, after the creation of the northwest and the north, yeah, as a region, and the creation of 2 new districts, Falaba and Kaine, the election came out. SLPP has 2 seats in Falaba. APC has 2 seats in Falaba, even though it was difficult in Kaine. But he returned a president when SLPP elected president. So for me, the issue about creating new districts, now in the fraction in 50+1, I am saying this here again on national radio and national television. The APC gets for belief in imposition. We, as SLPP and the members of Parliament, we are ready to remove the threshold of 25 or 20%, and we are ready to stick to 50+1 as recommended by the white paper of the APC-led government, as proposed by the APC in the Constitutional Review Committee, and let's move forward. Yeah.
So on the back off on that is what you say?
It is constitution. It's a bill before Parliament. A bill before Parliament is a text.
But what you know not the ground at the PR or first past the post?
Even the PR, they have also said that 38A is part of the Constitution. We are saying let's remember 38. Let's bring 38A as 38.4.
No, but what in this they propose that you remove first past the post totally from the Constitution?
No, so we are not saying that now. We are saying for them we all not be comfortable. If it's the people's choice, let us allow first past the post to be as 38.2 and 38A when we amend in 2001, let it come now as 38.4 and remember section 38.
So you still get all to the voting system
in the Constitution, and they said no.
Doc, you've been in this for a very long time, you know, from the tripartite, the agreement for national unity. You don't sit on at the different meetings them. And recently the AG was here and mentioned that you have been one of the members of the APC saying that the technical committee we've been getting engagement with. And some of the points he made was that we don't get agreement on most of some of the issues there are about PR, about the threshold for the election of the presidency and all. What's in change? Is it the document or the agreement change where it reached in Parliament?
Well, I should say if you watch the AG on Liberty TV, it contradicts itself, because on Liberty TV, he go further for say we not be don't agree on anything. We've been the discuss, yeah, but there's nothing like a definitive agreement. There were certain areas where be non-contentious. For example, the issue about the entrenched clauses, the need for make the removal. That was not contentious. We agreed. And you see, I want to make people understand. So there was a spirit behind the engagements. And the spirit was that how do we work out a constitutional arrangement we go stand the test of time and we go reflect the current realities, and that will be inform the discussions. However, we discover say whilst we were engaging in good faith, the SLPP been get other plans. For example, whereas we in the tripartite negotiations, we will think about how we can get a system we go prevent too many runoffs, we go prevent too much violence in elections, etc., etc. The issue of the threshold. Just when we come out from the tripartite committee discussions, now we get a proclamation from presidency to create new districts. And the moment they decide for create new districts, it does change the game plan. You know, and I think that's not bad enough. When they come now and go back with a bill in the parliament, the bill go totally against the spirit of the tripartite committee recommendations, you know. And so they begin suspect.
So there is issue of trust?
Exactly. There's a real
but the technical committee engagement will get now very recently, right?
Yes.
Now recent, not so after the agreement for national unity.
It was never conclusive. It was never conclusive, and even when we go for the retreat, we agree say it is not conclusive, but the parliamentarians go debate and further.
But were there things on agree on as with that time they want to spend with the meetings they want to get? Were there things on say okay, this way they giving on us giving on this way? There are things on agree on.
We be agree, for example, for remove the entrenched clauses. Okay, that one it was non-contentious. We discuss to a great extent the issue of the threshold, and we put forward some proposals. We believe for get a full meeting for low able reach conclusions, but the expectation was that when the Attorney General go in a parliament, it before go reflect the spirit of we discussions. In presentation at parliament, but sadly in presentation at parliament you not do that.
What's in that been for
example, when we discuss PR, even though we been get the reservations about the PR, and then even at the level of the retreat we agree say make it go back to the parliamentarians for discuss. We been propose options for discussion. We proposed mixed PR system, clarity on the PR system, and you would recall that in many democracies in the world they get different forms of electoral systems that they adopt. So we say let's have a discussion around that. So the expectation was that in the AG in presentation, enough for continue with a vague to just say PR.
Okay.
Without defining the type of PR.
But don't you say after the amendment then the electoral?
No.
Nobody wants some clearly defined.
You see, so what did they do? Question, you have to be clear. Especially we get serious trust deficits, and if you do so with all of these things, with under PR and then the district provisions where they put inside, they say we forget 20% in 2/3 of the districts. That it automatically means say APC forget 20% in 11 districts.
Let's just say that 19 at the document. It say the repeal and replacement of paragraph E of that subsection with the following paragraph: a person shall not be declared elected as president of Sierra Leone unless at the presidential election he obtains 1. a simple majority of the total valid vote cast throughout Sierra Leone, and 2. a minimum 20% of the total valid vote cast in at least 2/3 of the district of Sierra Leone.
Exactly. So if you get the 16 districts and you forget 2/3, it means that 11 districts. So if we get 7 districts in the north and the northwest, and then 2 in Freetown, that's 9. So you need for go at the southeast and get 2. But that was not the problem. The problem is that in the the proclamation where this government don't make, they intend to create 2 new districts. And nothing stops the president from creating 2 new districts. And if he creates 2 new districts, where he did within him powers for do, if this bill here pass as he did, then the 2/3 from when I still there in the draft, we need 14 districts at the country. So which means APC need for go get 5 districts at the southeast, which say they get 20% plus. That is almost impossible. When you look at the reality of how voting patterns don't be over the years. So clearly, as a party, would they see say they set trap for we? You know, when we don't get one discussion, for example, during the tripartite committee discussions, after so many considerations, the agreement then was that we go for 50+1 and then 25% in half of the districts, for just allow for inclusivity, for remove tension from elections, etc., etc. Sadly, the Attorney General will be a member of the tripartite committee. When he come now in this bill, he go against the letter and spirit of the tripartite committee recommendation. So instead of sticking to the 50+1, he changed to a simple majority, and that is totally different. And as if that's not bad enough, they also flag this proclamation for create additional districts, where just to explain, okay, will make it impossible for APC, or very difficult for APC for winning the first battle.
I want to seize this opportunity for extend my profound thanks and appreciation to honorable members of parliament of the opposition. I was fully persuaded and convinced, say, una they stand for the people there, and they stand for what's right. In democracy, challenges they can be. Sometimes they may not be easy, but come out and stand out. This now one of the finest opportunity we members of parliament and collaboratively don't decide for come out and stand out for the sake of the people of this country. Yes, we read the comments them we get out, and we as members of parliament not for be part of a procedure we not constitutional. This now the greatest document now this nation after the spiritual books, now the greatest document in this now this nation we now the constitution. Any amendment of the constitution we are not able to get the 2/3 majority, and not feel say we forbid a party to have. So this time we take, I want to thank all the members of parliament. The public may be doubt, but me, I was fully persuaded that we are together, we are in unity, we are stronger together, and our voices have spoken today a very strong message to the nation, say no force can divide us. So to honor the members of parliament, I want to honor plenty thank you. Yes. Because today now in parliament they go recess. When parliament reopens in October, we expect say una all they come in una full forces. We not take no boycott action against parliament. Let una know that day. Already we do now that we exclude recess from on procedural amendment of the constitution. So once more, I want to una thank you and may God bless Salome. May God bless you.
To the tripartite proposal, we have 50+1 plus half of the voting district. We say fine, let's go back to that. We go look. I have had meetings with the APC team, with Mayor Akisora, Dr. Kelfala Mara, Dr. Richard Conte, Ambassador Yansane, JFK, we all don't discuss, and everybody, and of course the members of parliament, everybody see we stick with 50 plus 1. So while we will come out on the eve of the debate in the parliament, the same people will don't come and say let's stick with the tripartite proposal because that's our proposal to the tripartite committee. The same people will come out and say no, we never want 50 plus 1, now 55% to 1. That is not leadership. That is not leadership.
You're surprised at the change? It seems like
I want to say I am disappointed.
In the APC people?
Yes, I want to say so. You understand? And they know. Look, I have worked with them a good deal. I have worked with them in good faith. They themselves don't talk publicly about how the office always on the open for engage. But if they get them kind of engagement issue, then una said they come, una recommend the engagement publicly. Una recommend them to the public. Una recommend them to international actors. Una recommend them among una own party members. See, this is the progress we have made. Then at the last minute, una turn behind people them and then try to take a different position. Then give
Mohamed, wait, man.
Mr. Minister, report on the bill.
Mr. Speaker, honorable members, I report that the bill entitled the Constitution of Sierra Leone Amendment Act 2026, having gone through the committee of the whole House with amendments, I now move that the bill be read the third time and passed into law.
Honorable members, the question is that the bill entitled the Constitution of Sierra Leone Amendment Act 2026 be read the third time and passed into law. All those in favor say aye. Aye. Those against say nay. The ayes have it.
The bill entitled the Constitution of Sierra Leone Amendment Act 2026, being an act to amend the Constitution of Sierra Leone 1991, Act number 6 of 1991, and to provide for other related matters, has been read the third time and passed into law.
In the circumstances, honorable members, I wish to make a ruling and to refer this matter to the Supreme Court for an opinion. The Constitution of Sierra Leone Amendment Bill 2025, now before this Honorable House, concerns the supreme law of the Republic of Sierra Leone. Its consideration therefore demands not only strict fidelity to constitutional procedure, but also a collective appreciation that a constitutional amendment is fundamentally a serious matter. The Constitution is the supreme expression of the sovereign will of the people. Consequently, any proposal to amend any provision of it must conform both to the letter and to the spirit of the constitutional provisions sought to be amended. In the current circumstances, I, as Speaker of the 6th Parliament of the Second Republic of Sierra Leone, have been invited to give a considered ruling on the threshold applicable to the Constitution of Sierra Leone Amendment Bill 2025. In doing so, I call on this House and by extension the citizens of the Republic of Sierra Leone to take keen note of the interplay between sections 91(1) and the entirety of section 108 of the Constitution of Sierra Leone Act number 6 of 1991. This issue concerns not merely the mechanics of voting, but the constitutional architecture governing the exercise of Parliament's constituent authority. As Speaker, I therefore consider it necessary to state the principles that ought to guide this House. Constitutional interpretation requires that provisions of the Constitution be read as a coherent whole and not in isolation. One provision should not be interpreted so as to render another ineffective, where both are capable of operating together. That being said, I invite this House to carefully read section 91(1) of the Constitution of Sierra Leone Act number 6 of 1991. Section 91(1) reads thus: except as otherwise provided for in this Constitution, any question proposed for decision in Parliament shall be determined by a majority of the votes of the members present and voting. This provision therefore automatically establishes the general rule for parliamentary decision making. any decision, including the decision to amend any provision of the Constitution not expressly provided for in this Constitution falls under this general rule. Incidentally, the Constitution of Sierra Leone 1991 does not make provision for the exception to this general rule. I therefore invite members of this House and by extension the citizens of Sierra Leone to carefully read sections such as 29.3, 119 subsection 9, 137 subsection 7, 137 subsection 10, and 173. Apart from these sections and others, there is definitely no section of general application that deals with a two-thirds majority requirement for decision making. The much trumpeted section 108 of the Constitution of Sierra Leone 1991 deals specifically with the provisions of section 108 and no other section. Section 108 subsection 2 only seeks to provide clear guidelines for the enactment of a new constitution, which definitely is not the case right now. Or other sections such as 108, chapter 3, section 146, section 56, section 72, section 73, section 74, subsection 2, section 74, subsection 3, section 84, subsection 2, section 85, section 87, section 105, section 110 to 119, section 120, section 121, section 122, section 123, section 124, section 128, section 129, section 131, section 132, section 133, section 135, section 136, section 137, section 140, section 151, section 156, and section 167 of the Constitution of Sierra Leone Act No. 6 of 1991. I invite all of us to the specific nature of the section, to invite all of us to the specific nature of this section, that is 108, the drafters constantly deploy the word this. Example, section 108, subsection 1 and 2 provide us. Subsection 1, subject to the provision of this section, my emphasis, subject to the provision of this section, Parliament may alter this Constitution. 2. A bill for an amendment of Parliament, a bill for an act of Parliament under this section shall not be passed by Parliament unless. I am therefore to state without attempting to go vernacular that this section means section 108, subsection 1, section 108, subsection 2, section 108, subsection 3, and up to section 108, subsection 9, and no other sections. I am also to draw your attention to the fact that all the provisions in the Constitution requiring a two-thirds vote for the amendment or alteration are mostly to be found under section 108, subsection 3. Since none of the provisions requiring a two-thirds vote for the amendment or alteration are to be found in the Constitution of Sierra Leone, Amendment Bill 2025, I will that this House will revert to the provisions in section 91, subsection 1 of the Constitution of Sierra Leone. Provision in section 91, subsection 1 of the Constitution of Sierra Leone, Act No. 6 of 1991, in deciding whether or not the bill becomes law. I do so pursuant to section 94, subsection 2 of the Constitution of Sierra Leone, Act No. 6 of 1991. Examples of the amendment of a non-entrenched section of the Constitution without recourse to a two-thirds majority are bound in this Parliament, including the amendment of section 79 in 2012 by voice collection only. However, since the question whether or not a non-entrenched constitutional provision can be altered by recourse only to section 91, subsection 1 of the Constitution, Act No. 6 of 1991, is of great public interest, I refer this question to the Supreme Court for an opinion to be returned to this House not later than 3 months today. So, during the voice collection, I ask all members to stand in their place and be counted by the clerk. All those in favor say aye. Stand up in your place, in your seat. Let me start clerk.
You saw one of the paramount chief enter the chamber. Mr. Yes, Mr. Deputy Speaker is here. And I ask you, do you have any personal excuse? Because in the computation for state of emergency, we always have people to excuse. A computation of so just asking him if there's any person or persons, or honorable members or members that are on excuse. The reason why I'm asking Mr. Speaker, is for the computation. You have not got voice, you have not got division in the house. That's it. For the computation of numbers, which by implication, when you are taking 2/3 of members of parliament, for state of emergency, we ask for the members under excuse, whether they are on medical or not. So we ask clerks to furnish this house with the full details for members who are on excuse, whether on medical reasons or otherwise. As I said, 2 colleagues entered as we are about to take it.
Yes, Mr. Clark.
Is here and the Deputy Speaker is here. So can we do another counting, please? I counted. Can we please do another counting? Okay. Thank you. Can we have a mind? Because you are required matter to Supreme Court. Order, please. You are required matter to Supreme Court representation. So we need to take every detail that has to be ruling. First, for examination, they will have to furnish this out. Order, please. Mr. Speaker, I need to put it out.
Yes, Mr. Clark, proceed, please.
I'm asking Mr. Speaker, that first the county should be loud. Secondly, to furnish this house. Those who are on medical excuse or otherwise should know that the computation of 2/3 and that's the members, those who take into consideration, whether thank you. Let me just take clarification.
Yes.
All those against say nay.
Move of Mr. Speaker, 97 members are present and voting by voice correction. In favor of the motion.
Honorable members, in the circumstances, the ayes have it.
The majority leader of government business, Honorable Ba Alpha Amadou Esquire of Western Area Urban is on excuse, and the excuse is with my office through one of my staff, written excuse. And Honorable Charles gave a verbal excuse of being sick and not being in Parliament. No, he wasn't in the chamber. Yes, he's absent. With excuse.
Mr. Speaker, so because he's absent and the Baba is, I consider that one to tender his excuse, whatever means he has in his office.
Of course, they will not be computed.
Okay.
They will not be considered in the computation of the numbers.
Okay, Mr.
Take note,
Mr. Speaker, the reason why I said so, in the removal of the Auditor General, we had members who were excused, and those numbers are not computed. So that's the reason I'm asking. So this has to do with the state and has to do with the constitution. So we have two members, and in fact, supported by what the clerk said, the other member was not in chamber today, or was not in Parliament today, and the other member is officially wrote a letter to the clerk and asked for excuse.
So, Mr. Clerk, hear the questions and refer to the Supreme Court. Thank you very much, Mr. Minister. You will leave. Honorable members.
Whip out. Whip out.
Honorable members, this sitting is adjourned to Thursday, the 29th of October, 2026.
Come on.
Nation, the Leone salon dey talk say for make you be president na this country, you for get 55% of the vote, otherwise we dey go for runoff. The government of salon dey propose say make we change that law, and they propose say for make person win the first round, you for get simple majority and at least 20% na third majority of the district in Salone. Wetin this mean? It means say the person for get the highest vote and also get at least 20% na 11 districts of the 16 districts who get na Salone. Because the argue say for make you be president, you for go all about na the country for get the mandate of the people. But we na Ilraj, we think say this na issue na with democracy. We na government of the people, by the people and for the people. We believe say if we lower the bar, we go create weak mandates for the president because it go appear say majority of the people we no want them, don't vote for them, and then the go come like can be president. We be say now few people vote for them. It also appear to be say some district in Salone them very small, other one them very big. So party we get base na small districts will end up win the election against the majority of this. It appear to we say the votes will be unequal. We go above the principle of democracy. We see one man, one vote. So now for pay attention and get involved. Of the tomorrow, bye bye. This message they come out from Ilraj.
You know, I don't listen to you, and I don't see now plenty time. You know, is it that you they pick and choose which one stands with waiting on a position, and the other one the way other institution and they raise we not stand with on a position is not valid in this conversation.
No, so everything other person don't say we take them as part of the process. For example, if you listen to debate in Parliament when it comes to 38, yeah. The APC accepts, the APC members of Parliament, and I'm sure that's the position of their party, that 38 and 38A is part of the Constitution. Well and good. So, my submission that for now, all these theory the AG presents about PR and non-PR, I say let us delete everything that the AG brought to Parliament. Now we take 38A and we number section 38 accordingly. 38A becomes 38.4. And in some paragraphs them, so at any time when any of the situation arise for either of the system of elections to be used, it can be used from the Constitution. They said no. So it's a point like whatever we say no to is no. So let me also address the issue of new districts. President Nkrumah created 2 new districts. Not only created 2 new districts, he changed the political landscape of Sierra Leone. He creates Northwest region and he create a northern region. Nobody in the SLP will not see enough for political advantage because we believe in Sierra Leone.
No, then there was you and cry.
There was you and cry, but the point is,
he was condemned for doing that.
Yes,
it was part of the conversation that because of politics, because the one get more seat na the north and northwest. That was why he was doing it.
So what happened in the end? In the end, after the creation of the northwest and the north, yeah, as a region, and the creation of 2 new districts, Falaba and Kaine, the election came out. SLPP has 2 seats in Falaba. APC has 2 seats in Falaba, even though it was difficult in Kaine. But he returned a president when SLPP elected president. So for me, the issue about creating new districts, now in the fraction in 50+1, I am saying this here again on national radio and national television. The APC get for believe in imposition. We as SLPP and the members of Parliament, we are ready to remove the threshold of 25 or 20%, and we are ready to stick to 50+1 as recommended by the white paper of the APC-led government, as proposed by the APC in the Constitutional Review Committee, and let's move forward. Yeah.
So on the back off on that is what you say?
It is constitution. It's a bill before Parliament. A bill before Parliament is a text.
But what you know not the ground at the PR or first past the post?
Even the PR, they have also said that 38A is part of the constitution. We are saying let's remember 38. Let's bring 38A as 38.4.
No, but what in this they propose that you remove first past the post totally from the constitution?
No, so we are not saying that now. We are saying for them we all not be comfortable. If it's the people's choice, let us allow first past the post to be as 38.2 and 38A when we amend in 2001, let it come now as 38.4 and remember section 38.
So you still get all to the voting system
in the constitution, and they said no.
Doc, you've been in this for a very long time, you know, from the tripartite agreement for national unity. You don't sit on at the different meetings them. And recently the AG was here and mentioned that been one of the members of the APC said that the technical committee we've been getting engagement with. And some of the points he made was that we don't get agreement on most of some of the issues there are about PR, about the threshold for the election of the presidency and all. What's in change? Is it the document or the agreement change where it reached in parliament?
Well, I should say if you watch the AG on Liberty TV, it contradicts itself, because on Liberty TV he go further for say we not be don't agree on anything. We've been the discuss, yeah, but there's nothing like a definitive agreement. There were certain areas where be non-contentious. For example, the issue about the entrenched clauses, the need for make the removal. That was not contentious. We agreed. And you see, I want to make people understand. So there was a spirit behind the engagements. And the spirit was that how do we work out a constitutional arrangement? We go stand the test of time. And we go reflect the current realities. And that will be inform the discussions. However, we discovered, say, whilst we were engaging in good faith, the SLPP been get other plans. For example, whilst we in the tripartite negotiations, we will think about how we can get a system we go prevent too many runoffs, we go prevent too much violence in elections, etc., etc. The issue of the threshold. Just when we come out from the tripartite committee discussions, now we get a proclamation from presidency to create new districts. And the moment they decide for create new districts, it don't change the game plan. You know, and I think that's not bad enough. When they come now and go back with a bill in the parliament, the bill go totally against the spirit of the tripartite committee recommendations, you know, and so they begin suspect.
So there is issue of trust.
Exactly. There is a real.
But the technical committee engagement will not get now very recently, right?
Yes.
Now recent, not so after the agreement for national unity.
It was never conclusive. It was never conclusive, and even when we go for the retreat, now, we agree say. It is not conclusive, but the parliamentarians go debate and further.
But were there things on agree on as with that time they want to spend the meetings they want to get? Were there things on say okay, this way they giving on us giving on this way? There are things on agree on.
We be agree, for example, for remove the entrenched clauses. Okay, that one it was non-contentious. We discuss. To a great extent, the issue of the threshold. And we put forward some proposals. We believe for get a full meeting for low reach conclusions. But the expectation was that when the Attorney General go in a parliament, it before go reflect the spirit of we discussions in presentation at parliament. But sadly, in presentation at parliament, you don't do that.
What's in on the for
example, when we discuss PR, even though we've been get the reservations about the PR, and then even at the level of the retreat, we agree say make it go back to the parliamentarians for discuss. We've been proposed options for discussion. We've been proposed mixed PR system, clarity on the PR system, and no. And you would recall that in many democracies in the world, they get different forms of electoral systems that they adopt. So we say, let's have a discussion around that. So the expectation was that in the AG in presentation, enough for continue with a vague to just say PR.
Okay.
Without defining the type of PR.
But don't you say after the amendment, then the electoral?
No.
Only want some clearly defined.
You see, so what did they do? Question, if I be clear. especially we get serious trust deficits. And if you do, so with all of these things, with under PR and then the district provisions where they put inside, they say we forget 20% in 2/3 of the districts. That it automatically means APC forget 20% in 11 districts.
Let's just say that 19 at the document. It say the repeal and replacement of paragraph E of that subsection with the following paragraph is: a person shall not be declared elected as president of Sierra Leone unless at the presidential election he obtains 1. a simple majority of the total valid vote cast throughout Sierra Leone, and 2. a minimum 20% of the total valid vote cast in at least 2/3 of the district of Sierra Leone.
Exactly. So if you get the 16 districts and you forget 2/3, it means there are 11 districts. So if we get 7 districts in the north and the northwest, and then 2 in Freetown, that's 9. So you need for go at the southeast and get 2. But that was not the problem. The problem is that in the proclamation where this government don't make, they intend to create 2 new districts. And nothing stops the president from creating 2 new districts. And if he creates 2 new districts, where he did within him powers for do, if this bill here pass as he did, then they forget 2/3 from when I still there in the draft, we need 14 districts at the country. So which means APC need for go get 5 districts at the southeast, which say they get 20% plus. That is almost impossible when you look at the reality of how voting patterns don't be over the years. So clearly, as a party, would they see say they set sharp for we? You know, when we don't get one discussion, for example, during the tripartite committee discussions, after so many considerations, the agreement then was that we go for 50+1 and then 25% in half of the districts, for just allow for inclusivity, for remove tension from elections, etc., etc. Sadly, the Attorney General will be a member of the tripartite committee. When he come now in this bill, he go against the letter and spirit of the tripartite committee recommendation. So instead of sticking to the 50+1, he changed to a simple majority, and that is totally different. And as if that's not bad enough, they also flag this proclamation for create additional districts, where just to explain, we're going to make it impossible for APC, very difficult for APC for winning the first battle.